The Honorable, the Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Thank you, Mr. Minner. Good morning, everyone. Welcome to the first day of our fall oral argument session here in our magnificent courtroom in Pittsburgh. As some of you know, the Pennsylvania Supreme Court is the oldest appellate court in North America, and our roots date back to William Penn's Provincial Court of 1684. Our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722, and in May we celebrated our 300th anniversary in Philadelphia with a special session in Old City Hall and a two-day symposium at the National Convention Center. We on the court are very proud of our rich history. Today, as you will notice, there are only 6 judges on the bench. Our beloved colleague, Chief Justice Max Baer, passed away on October 1st. This is a tremendous loss for our court and for all of our state judiciary. Pennsylvania has lost a jurist who served the court and the citizens of our Commonwealth with distinction. Chief Justice Baer was an influential and intellectual justice whose unwavering focus was on administering fair and balanced justice. He was a tireless champion for children, devoted to protecting and providing for our youngest and most vulnerable citizens. His distinguished service and commitment to justice and fairness spanned his decades on the bench, first as a family court judge here in Allegheny County, then as the administrative judge of our family court, before being elected to serve on our Supreme Court. On behalf of my colleagues, the justices of the Pennsylvania Supreme Court, we offer our deepest condolences to Beth Baer, Justice Baer's sons, the rest of his family, his friends, and his staff, some of whom are with us here today. Anyone who ever appeared before this court or observed our argument sessions knows that Chief Justice Baer was collegial to everyone in the courtroom. He was compassionate toward the litigants and their positions. Most of all, he was committed to deciding cases in a thoughtful, fair, and impartial manner. As we continue to mourn his passing, we know that the best way for our court to honor his memory is to continue to serve the people of the Commonwealth with dedication and fidelity to the law. Before we begin our session, I would like to acknowledge some students who are visiting with us today. First, we have students from the Thomas R. Klein School of Law at Duquesne University. These students are from the Appellate Process and Procedure class, which is co-taught by retired Superior Court Judge and Duquesne University Law School Dean, our friend Maureen Lally-Green, and by attorney David Belchick. Would those students and their professor please stand? Welcome, welcome. I hope that you enjoy the arguments today, and it will be extra pressure on the attorneys to do a fine job. Thank you. Also visiting with us today are some foreign exchange students from the University of Cologne in Germany, which partners with the Thomas R. Klein School of Law at Duquesne University. They are supervised by the law school's externship director, Professor Grace Orsatti, and they are here with their externship coordinator, Zachary Volkosi. Would you all please stand? Willkommen. We're glad you're here with us. Before the court calls the first case, I would like to briefly remind counsel of a few matters of protocol. Please approach the podium when your case is called. I will then give a very brief summary of the case, which you can correct if I have misstated anything. Then you begin by introducing yourself and your co-counsel, please, and identifying the party that you represent. As you know, if you have observed our court in the past or argued cases before us, our justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of the facts or of the procedural history and proceed directly to the issues on which we accepted review. Counsel are free to rely on their briefs for particular issues if they so desire. In cases where there are multiple parties represented by separate counsel, counsel should not repeat the same arguments as prior counsel. Previous Chief Justices have referred to this as the no piling on rule, so we will enforce that today as well. Please don't interrupt the justices as we ask you questions. We're not trying to trip you up. Rather, questions indicate that we're very interested in your case and there are particular issues that we wish to explore further. I would also point out our court does not permit rebuttal argument. Finally, while we have no time limits here, I will advise counsel when we have heard enough, and at that time, I would ask you to conclude your argument. If you don't conclude, you may see the justices turning their lamps off, and that is a good indication that your argument should conclude. Mr. Minner, would you call the first case?
The Bert Company doing business at Northwest Insurance Services, appeal of Matthew Turk. Representing appellants is Mr. Scott Sesser. Representing Northwest Insurance Services, Mr. Kenneth Africano.
Please approach. In this matter of first impression, which concerns a due process challenge to a punitive damage award under the 14th Amendment of the United States Constitution, we consider whether a punitive to compensatory damage ratio exceeding 9-to-1 is constitutional. We also consider whether potential versus actual damages may be considered in evaluating the excessiveness of a punitive damages award. Finally, we are asked to determine the proper method of calculating the punitive to compensatory damages ratio in cases involving multiple defendants.
Good morning. Chief Justice Todd, fellow justices of the Pennsylvania Supreme Court, my name is Scott Sesser, and I represent the appellants in this case. Question one, I'll get right to it. Is a double-digit ratio of punitive to compensatory damages presumptively unconstitutional because it's in conflict with U.S. Supreme Court precedent? Here, the lower court upheld an 11.2-to-1 ratio in a commercial case involving a verdict for purely commercial, strike that, for purely economic but substantial compensatory damages of $250,000. We respectfully submit that the lower court erred in applying the binding U.S. Supreme Court precedent. The lower court discussed the Gore case of 1996 and the State Farm case, but really they relied on the TXO case from 1993, which was a plurality opinion. Gore established the Gore guideposts, and then 7 years later in State Farm, the court refined the Gore guideposts and expressly stated three principles. Number one, few awards exceeding a single-digit ratio. Few awards, that is, between punitive and compensatory damages will satisfy due process. Keep in mind that the lower court here held that it was presumptively constitutional if it exceeded. Number two, the Supreme Court in State Farm said an award of more than 4-to-1 is close to the, quote, line of constitutional impropriety. Most critical here for my client, the court said when compensatory damages are substantial, then a lesser ratio, perhaps only equal 1-to-1, can reach the outermost limit of the due process guarantee. And here, the plaintiffs were awarded $250,000 in compensatory damages, which the case law deems to be substantial.
Can you, Mr. Sesser, can you, my condolences on your father's passing, by the way.
Thank you very much.
can you give us any kind of insight from your reading of the SCOTUS precedent on how we are to interpret that term substantial? Does that vary according to the jurisdiction within a given state, or is there some sort of nationwide yardstick of what's substantial?
There is no nationwide yardstick. It seems to be somewhat elastic, but you still have to apply the Gore guideposts, and you need to review the facts under the Cooper Industry case, not in favor of the verdict finder, the party who won below, but you need to look at it from both sides of the coin. I don't know if I'm answering your question exactly, but
well, I think your use of the term elastic is apropos, because everything in the body of case law we have from SCOTUS in this area is highly elastic. And I wonder if, given the wiggle words that Justice Kennedy used, for example, to a significant degree or substantial, whether Gore or State Farm or any of the case law, how you think we can glean from any of that, or I suppose how we should glean from any of that, a specific yardstick.
it's a difficult task to face the court. If you look at Justice Souter's majority opinion in the Exxon Valdez case, which was several years later, he went through a super explanation of all the different states. Some have statutes, some have judge-made. He came back to the finding that a 1-to-1 ratio, where compensatory damages are substantial to punitive damages, was appropriate. And what he talked about was the fact that the ratio is critical to the deterrence aspect of punitive damages. Punitive damages are to punish and to deter. And as he said, and he quoted Justice Holmes, the bad man was what Justice Holmes used. And he said, frankly, if we don't have some sort of ratios that have some limits or specificity, then we don't have deterrence for the quote-unquote bad man that Justice Holmes used.
Counsel, could you state for us your position on whether or not we should look at the ratio as a lump sum, so to speak, or if we should look at it in the context of the punitive damages allocated to each defendant? Because, of course, if we look at it in the latter sense, we don't have a ratio that exceeds single digits as to any of the defendants, and therefore that issue is mooted out in that context.
Certainly, Justice Donohue. Here, we have joint tortfeasors with joint and several liability. The case went to trial, to verdict, with 6 causes of action against 7 defendants. And the jury verdict slip was like the slips we've all seen when we've tried these cases. There was an express instruction to the jury that whatever to the highest number went on any count would be the number that would be the total liability that would be shared joint and severally between all the defendants. Here, a number of the defendants were exculpated entirely. 2 counts were zeroed. The highest number was $250,000. We submit to the court that you should use the per judgment approach as opposed to the per defendant approach. And the reason is fairly simple. If you look at the potential absurdity that can result if you use the per defendant. Imagine a case where you have 9 defendants and there's $100,000 in joint and several liability, but there's a 9-to-1 finding for punitive damages because it's one of those exemplary cases. So if you take 10 defendants with potentially $900,000 punitive damages each, you end up with a $9 million punitive damage award with only $100,000 of compensatories. So you essentially have a 90-to-1 ratio.
But that's not what we have here, counsel. So let's just focus on the award here and the allocation of punitive damages. Wasn't it within the realm of the jury's deliberative and findings authority to determine that one of the defendants was more responsible and more culpable in a punitive damage sense than the other defendants? And if they did that, what's wrong with that decision-making process on the part of the jury?
Because essentially you're counting the compensatory damages 4 times here. You're counting $250,000 to be allocated against each of the defendants that were hit with punitive damages. So you're not just taking a double bite, you're taking a four bite of the compensatory damages, because no particular individual defendant could be liable for more than $250,000. So why should they be liable in toto for 11.2 to 1?
But the accumulation of the damages occurred as a matter of law. The jury made individualized determinations as to the amount of compensatory damages allocable to each of the defendants. So why don't we look at the entirety of the jury's award in making a determination on the correctness of allocating punitive damages per defendant as opposed to per judgment, which was accumulated as a matter of law because of the joint tortfeasor status?
Well, here we have a corporate family. So the case was tried that way, as if all the defendants were linked together.
But not Mr. Turk. Mr. Turk is not part of your corporate family, isn't that right?
He was an employee by the time the case went to trial, and he was represented by all the same counsel.
So for purposes of your argument here, then, is it necessary that you include Mr. Turk in your corporate family?
Yes.
The jury awarded individualized amounts to each of these, against each of these defendants on the punitive claims, right?
Correct.
And had it been appropriate for any of these defendants not to be on the hook for punitives, presumably they could have been non-suited, right?
That's correct. And several of the defendants had a 0 against their name in terms of any damages, compensatory or punitive.
Isn't that key? However, I get back to my question. A lot of what you're asking us to consider is based upon a fiction, if you'll allow me to use that phrase, of what the jury did, and the fiction is based upon what is required as a matter of law. But correct me if I'm wrong, this jury allocated compensatory damages per defendant also.
They did, Your Honor.
And so what you're asking us to do is take into account the fiction of one corporate entity, the fiction that the jury did not award individualized damages to each of the named defendants that are before us, and then make a decision based upon that burnished analysis that we must consider the ratio to the judgment and not to the individualized defendants. Am I understanding correctly the facts and the legal consequences of what occurred from the jury's verdict?
I think you restated very accurately, Your Honor, the substance of the verdict. And what we're asking you to do is to treat and do it on a per judgment basis as opposed to per defendant basis, because this is going to be the precedent in Pennsylvania from now on. You're going to have multiple defendant cases with many defendants, and you could have cases like the Planned Parenthood case, where you have a multitude of defendants. And in that case, the lower court, the Ninth Circuit, didn't even address really the issue of the double counting. Neither of the two cases relied upon by the Superior Court have addressed the issue of the double counting. And in both cases, they just sort of accepted it. But in the Ninth Circuit case, where you had a RICO violation against protesters for threatening doctors, even in that case, the Ninth Circuit, they simply vacated and remitted down to 4 times. In the Texas case relied upon by the Superior Court, the court sort of just accepted, let's count it this way, and then they vacated the punitive damages in their entirety on facts which were much more severe than the facts here.
But you say that it just vacated it. It was done on a principle that strikes me as correct, that constitutional rights, which you're arguing are being violated here, are assessed on an individual basis, not a cumulative basis. Punitive damages are assessed based upon the conduct of individualized defendants, and so consequently, when you're looking at the ratio that's not set in stone anyway, you really need to look at it on an individualized basis. That, to me, is not a unprincipled basis for the Texas Supreme Court to have come to the conclusion that it did.
Well, the Texas Supreme Court really didn't put much thought into it. If you read the opinion, there's not much rationale to it.
I did.
Okay.
I read it. And
I apologize, Your Honor.
You may think that the rationale is skimpy, but I think that their precise holding, be it only a sentence or two, sort of captures the issue as it's presented.
But we'll consider also the unfairness to the individual defendant. It's, you know, on a per-judgment basis, you know, you have the potential for, like I said before, $100,000 in compensatory damages, feeding an unlimited high amount of potential punitive damages.
Can I follow up on that? So you want on the one hand to conduct yourselves with whatever presumptive benefits there are from perfectly legal corporate structuring, FNB, FNIA, et cetera, and have these different entities which have different legal existence, but you don't want to have those same you don't want to face the consequences of that on the back end here. So I don't understand the disconnect there, and again, I don't understand why you're not adequately protected in the law by the availability of non-suit summary judgment, directed verdict, whatever. That's number one. But number two, on your argument about the aggregation and the per judgment, suppose you had two defendants, and suppose you had an enormous punitive award against one of them, and it's a tiny punitive award against the other. Since it's per judgment in your theory, then you'd have to say that $1 award against the less culpable defendant would also violate due process. How can that be?
Well, wouldn't you, if they were they're joint tortfeasors?
Yes.
So if they're joint tortfeasors, you would look at the overall high amount, whatever this amount was, and do a calculation of the ratio and determine if it was constitutionally permissible.
Counsel, permit me. The way I see this is the concept of compensatory is the determination of liability. So a determination, this is punitives, is now looking at the reprehensibility of the defendant's conduct. Since the Supreme Court put due process directly at issue, share with me why I should not convince my colleagues that in Pennsylvania the due process protection provided to the defendant would be their net worth, and that being attacked by the net worth as opposed to this ratio. I'm having a problem, despite the statute, or despite the case law, as to how reprehensible conduct caused by the defendant should have any way interfered with the liability portion of the compensatory damage. I see them as two complete different things. We're here to stop the defendant from being rotten and evil. What we're here is saying, hey, wealthy corporations can hurt and be protected because of this due process argument. And that could flip today. So share with me why it shouldn't flip.
Right. If I understand your question, Your Honor, let me respond this way. If you read the jurisprudence of State Farm and Exxon, you know,
I did.
One of the concerns is to protect large corporations from unfavorable juries in remote areas.
But should that not be the due process? The issue here is due process.
It's due process of property.
Should we not protect their due process by putting their net worth at issue and permit the jury to determine how reprehensible their conduct was, which is the purpose of punitives, even if the majority of our judges don't get to punitives?
I believe in State Farm, the net worth of State Farm was put at issue. I mean, there could be cases where that is appropriate. Here, it was not put at issue in terms of the net worth of either of the companies.
I know. That's why I'm raising the question.
Right. It just wasn't put at issue here.
Okay.
Back to this issue of one corporate entity, an umbrella, whatever the term you use to describe this joint action on the part of the multiple corporate defendants. Obviously, there was evidence in this record that convinced the jury that certain of the corporate actors were more reprehensible in their conduct than others. I mean, I keep getting back to this point. This is a jury verdict, a jury's determination. I might add, in the Court of Common Pleas of Warren and Forest counties before an exceptional trial judge who decided, based upon the evidence, that FNIA was far more reprehensible in its conduct than the others. I mean, what is the principled reason for ignoring that jury determination, which gets us to a 6-to-1 ratio below the, within the single-digit ratio that you're arguing for? How do we ignore that jury determination?
It goes back to fundamental due process and having an apples-to-apples comparison and not double counting the amount of compensatory damages. And I would add, Your Honor, beyond that, we've argued to the court that you should follow the Gore guideposts, which the Superior Court did not review or address. They mentioned them, but they did no analysis of the Gore guideposts. And it should be a de novo review, Your Honor. It shouldn't be reading the facts in the light most favorable to the verdict finder. If you look at State Farm, Gore, and also Exxon, there's a balanced review of the facts. That's why we spent a lot of time in our briefs, Your Honor, outlining the facts. So if Your Honor feels constrained that, it shouldn't be apples to apples, it should be per defendant as opposed per judgment, we would respectfully request the court to review those parts of our brief, that a 1-to-1 ratio is more appropriate here. And if you look at the facts of the cases relied on them, the Horizon case, the Planned Parenthood case, other cases, if you even look at Justice Mundy's decision in the Grossi case, Your Honor, which you were part of, I mean, that was a statutory bad faith case where there were only attorney's fees, penalties, and interest, and that was like 4-to-1. So, here, even at 6-to-1, you're beyond sort of the bounds of what's fair under the facts, with all due respect, with our position.
But hasn't SCOTUS repeatedly said there is no bright line, no specific number, no specific ratio?
They've said that, and it's, like I said, it's somewhat elastic, and it is come down to judge-made law in the different states based on issues of public policy, what seems fair, what seems right. This court hasn't spoken on punitive damages since XTO or earlier, as far as I could decipher.
And I just want to take one more stab at this corporate family subject. I can understand your argument were it a case of throwing entities against the wall, so to speak, and just saying, here's 10, let's find 100 affiliates, let's throw 100 affiliates there to ramp up the punitives. But here they put in evidence on these individual affiliates or entities, and as you pointed out, some of them got zeroed out. But Muchnock was with FNIA, and Moorhead was with FNB, right? And there was other, so that there seems a semblance of rationality to the jury's breakdown, and I guess I'm searching for your proffered standard as to how we're supposed to supplant that verdict simply because there is more than one entity in the family here.
It comes back, in our view, to apples. You can only count it once. If you count it more than once, it's unfair, just patently unfair.
I guess I could understand that argument if the jury came back with the same punitive damage award as to each of these individually named defendants. But that's not what they did. I mean, they obviously relied on the evidence presented to make a conclusion that one was much more heinously terrible in its conduct than the other. So, I mean, I understand the notion that in this context, courts have taken it upon themselves to mold the jury's verdict in terms of the punitive damage award, but this one seems to have such precision to it. And I'm just going to add this phrase, although this is a Pennsylvania or state law phrase. God forbid we should talk about how state Supreme Courts look at this as opposed to the United States Supreme Court, but nothing about this shocks my conscience. I mean, and, you know, I guess at the end of the day, you know, as you know, you do this ratio analysis and things of that nature, isn't that somewhat what your ratio gets you to? Too much, it's just bad, it doesn't feel right.
It is too much here, Your Honor. I would agree with you. You know, it seems to me 1-to-1 is like the outermost limit that should be here in view of the facts, if the facts are viewed with both sides of the coin, as the Cooper Industries and the other cases instruct. You know, 6-to-1, you know, the ratios are substantial.
Mr. Sesser, it seems to me, though, that most of your argument is focused on ratio and that your argument kind of disregards the reprehensibility focus. Is that, is my understanding of your argument accurate?
No, Your Honor. We spent quite a bit of time on the reprehensibility analysis.
You did.
In our brief.
You did, but it seems to me that you're weighing ratio as much more important than reprehensibility, when my reading of the case law indicates otherwise, that maybe we ought to be focused more on reprehensibility.
Exactly, Your Honor, because, and I have a lengthy discussion here, which I'm just beyond my time here, but if you apply the Gore
There's no
guideposts.
time limit until
Okay.
we say it's over.
Oh, okay. I'm earning my keep today then. Under the Gore guideposts, the reprehensibility analysis, the most important one is factor 1. That's the reprehensibility, Gore guidepost 1. And 4 out of the 5 factors here are not present. There was no physical harm. It was purely economic. Number 2 was a business tort. There was no disregard of health or safety here. Number 3, the plaintiff was a thriving business. They went on. They lost 2 producers, an assistant, and someone in the Pittsburgh office. Number 4, there was no recidivism or evidence of any conduct. This was the single recruitment of 4 employees. The only factor which is implicated is the malice factor, which is factor 5 of number 1, of Gore guidepost number 1. But there's no trickery or deceit here. The jury did not award any money on claims of stealing trade secrets or tortious interference. If you find malice here, then all lift-outs would be subject to punitive damages.
Wait a minute. Putting malice aside, how can you say that this jury could not have discerned trickery and deceit in what appears to have been at least colorably? It could certainly be said that the jury found trickery or deceit in this plan to lift out all the business of NWI, right?
I don't disagree with you. In fact, the lower court, and I skipped over this in my notes, that was the one finding. The Superior Court didn't make any findings as the guideposts, but the Superior Court did find malice. But if you look at the cases that we've cited, including the Texas case, which they rely on, it was a worse set of situation where a bunch of people were working in an insurance company. The CEO left and started a new company. These people working in the existing company got up, moved, and took a bunch of business with them. And the court said that's not enough for punitive damages.
Well, that's because there's a difference between a lift-out and a lift-out that constitutes unfair competition. A regular lift-out, remember, Pennsylvania law doesn't like restraints of trade. We don't like covenants not to compete. We'll enforce them. They have to be very narrow, but we don't like them because we don't like restraints on trade. So the idea that we're just going to say every lift-out is bad, we don't do that in Pennsylvania. But we do have a cause of action for unfair competition where the lift-out is not just to get good employees, but is to destroy the competitor. That's when it becomes an unfair competition lift-out. And that's what we had here. And that's what the jury found. So it seems to me like every unfair competition of this type would invite punitive damages. How am I wrong?
Well, it at least would satisfy one of the 5 factors of guidepost 1. And the question then will be, is that enough in order to get to punitive damages?
Personally, I'm struggling with Gore in the sense that, guidepost factors, it's the language, I agree with Justice Weck, is a little bit loose. Guideposts, factors, we're not setting hard numbers. Again, I wonder whether we're toiling a little bit about what obscenity is. As Justice Donahue said, we'll know it when we see it.
And one of the dissents in one of the cases said that as well, in one of the Supreme Court cases. I can't recall off the top of my head, but.
Counsel, back to these guideposts, what are you saying? We are bound to follow those nebulous guideposts in deciding this case? I mean, can we, as a state Supreme Court, highest court in this Commonwealth, decide they just aren't helpful to us?
With all due respect, I don't believe so, based on the case law, the Supreme Court case law that's come down that says that, the due process, the property part of the due process clause of the 14th Amendment has bite and applies to the states.
What's binding about a guidepost? I mean, we could say none of the guideposts are met. However, we find that there's nothing wrong with this punitive damage award.
Yeah.
Or one of the guideposts is met and it's sufficient under these circumstances. I mean, those guideposts seem to suggest that unless you have a significant personal injury, punitive damages are not as readily available for commercial misconduct as we have here. Is
Which
that
cannot
right?
possibly be the case, or we would never be discussing
Can't be.
punitive damages in this kind of a commercial setting.
I mean, we wouldn't be here. I mean, that's what I'm saying. I mean, this issue of the we must file those guideposts. Okay, we'll say we've gone through every one of the guideposts. Only one of them seems to apply here. That's enough. I mean, we're free to do that, correct?
This court's free to do, whatever it wants. I mean, I don't want to seem presumptuous to tell you what's binding.
Until the United States Supreme Court tells us we can't do what we've always done.
Right.
But that's a different issue.
The only thing I would suggest, when you look at the jurisprudence from the circuit courts and the other states, they've adhered to the guideposts, and at least
Those don't bind us, of course. SCOTUS binds us on the Federal Due Process Clause. And as far as searching for a standard by which we are bound in preparation for this argument, I've encountered a lot of mush. I mean, I use the term wiggle words, and that's what Gore and State Farm have a lot of. I see the word perhaps appearing more than once, substantial degree, guidepost itself is a wiggle word. And so I guess I'm still searching for how this doesn't give us essentially a lot of dicta rather than binding ratios, which you seem to want us to adopt.
Yeah, as I said before, I believe not binding ratios, but ratios that send a message will be helpful for the litigants in the courts of this Commonwealth in terms of what are permissible bounds of punitive
I think
damage.
the word's presumptive, right? And
sorry?
I think the word that you're looking for is not permissible. I think the word you're looking for is presumptive, right? A ratio above which something would be presumptively unconstitutional. Is that?
I said permissive, so that's what I meant more of, some greater guidance, because there hasn't been a decision of this court on punitive damages since State Farm and TXO and Gore came out.
I thought the question was whether a ratio exceeding 9-to-1 is presumptively unconstitutional.
That is question one, and we
Right. So hypothetically, if we were to say anything above 9-to-1 is presumptively unconstitutional, what happens? Is there a burden shifting that happens at the trial court post-jury verdict where now it's presumptively unconstitutional and the prevailing plaintiff has to come forward with evidence to argue that although presumptively we can rebut the presumption?
Well, under the regime with punitive damages, the trial court followed by the appellate court always serves as a reviewing court with de novo powers to look at the award. So if this court sends out a certain guidance or direction, that would be applied by the trial court, and it might be that they remit it to whatever.
Is it a rebuttable presumption?
That's a good question. I mean, there could be some set of facts that's so egregious, as Justice Donohue alluded to, involving personal injury. Somebody shoots a gun into a crowd, right? And it only hits a pair of eyeglasses, and it's $100 to fix it.
Well, the answer then is yes, it could be
It could be,
rebuttable
yes.
presumption.
Yes.
What presumptively would suggest, doesn't it? Otherwise, it would be cannot exceed, right?
That's fair to say.
Mr. Sesser, do you want to,
Sure, I just want.
Chief Justice, pardon me. Could I, before he concludes, may I ask Mr. Sesser one other thing? Thank you, Chief. I wanted to ask you on pages 32 and 33, you faithfully quote State Farm, and I wanted to get your take on that. The quote from State Farm is, when compensatory damages are substantial, then a lesser ratio, perhaps only equal to compensatory damages, can reach the outermost limit of the due process guarantee. So I don't know if Justice Kennedy was musing there or what was going on there, because it seems to me, and I wanted to get your reaction to this, one could make the opposite argument too, or I would anticipate that you would. For example, suppose the compensatory damages were first of all, we don't know what substantial means, but put that aside. Suppose compensatory damages were insubstantial. Then wouldn't we anticipate that the defendant would argue on appeal that this wild disproportion is beyond the outermost limits of due process? Do you see what I'm saying?
I see exactly what you're saying.
So-
It goes back to my
I just
hypothetical with
don't
the
know how you make
glasses.
sense of any of this. Is it dictum? How does it guide us? What should we do with that?
I think you should do your best to try to faithfully apply to it and send a message to the trial courts and the litigants that lets people know what is going to deter conduct, what they have to expect, what the bad man, as Justice Holmes said, needs to expect. And we believe a 1-to-1 ratio on compensatory to punitives when there's substantial compensatory damage such as here is most appropriate.
Counsel, isn't that in and of itself a nebulous concept? What is substantial compensatory damages?
Yeah.
I mean, at one point in your brief, you argue that these are substantial compensatory damages. At another point in your brief, you argue that it was only $250,000. That's the problem. I mean, so what is substantial?
Yeah.
And I don't know if you can answer that question. I'm just saying it's just another one of those phrases, one of those descriptors in this entire body of case law that leaves you without any definitive guidance.
Sure, and let me explain. If you look in our reply brief, and I forget what page 18 or so, there is a list of cases that describe why $250,000 is substantial under all the jurisprudence that's looked at this, number one. Number two, when we talked about the $250,000 compensatory award not being that great, it's because the plaintiffs chalkboarded $4 million. And the jury, it sort of goes to the issue of how reprehensible was our conduct if they chalkboarded $4 million and the jury only came back with $250,000.
It could be because the jury decided that it was the intention of the defendants to entirely destroy the company that was worth $9.8 million or whatever the figure was, but they didn't quite get there.
It's funny.
And that gets to the issue of, can you take into account that concept? I think the Superior Court refers to it as future damages or could have been damages. Is that a legitimate question for us to address?
Yeah, I believe if there are cases where the compensatory damages are going to be low, my hypothetical of someone shooting a gun off and hitting my glasses, I'm in a crowd and it's $100, then future potential harm may be something you can consider. I do want to address, Your Honor, and
What would that be? Follow that through for me, because I think that's a really good example of the compensatory damages might be $99 because the eyeglasses came from Warby Parker. But the reprehensible nature of that conduct is such that it would support a very high punitive damage amount to deter that conduct and to establish it's reprehensible.
yeah, I'm relying on what the Supreme Court said, I believe,
I know, but
in
I'm
Gore.
asking you to help me with
Sure.
what the Supreme Court is saying, because I think that at least some of us are of the view that it's clear as mud as to what we're looking at here.
But let me suggest this to you. You shouldn't even get to potential harm here. The $9.4 million figure that's cited by the Superior Court, and this isn't my brief because I found it out when I was preparing for argument. At page 129, they claim the Bert company was worth $9.4 million. And that's how they do their analysis to say, look at the possible future potential harm. That was never argued to the jury. It was never presented to the jury. And the $9.4 million cite is to the gross revenue of the Bert company the prior year. And there's a world of difference between the gross revenue of a company and the fair market value.
Was that in the record?
It's not in anything that we submitted, but
I'm talking about the record that was before the jury.
what was before the jury was that the gross revenue was $9.4 million. It wasn't what the fair market value of the Bert company was. So I suggest to you the issue of potential harm is one that shouldn't be reached here even, because it wasn't argued to the jury, it wasn't presented to the jury, and the citation by the Superior Court to the record is not factual.
All right, if you want to sum up, we'll move on to the Appellee's argument.
Yes, members of the court, we would respectfully request that based on the reprehensibility analysis and the Gore guidepost, that you reverse this decision and you either vacate the punitive damages or reduce it to 1-to-1, or we also invited the court to do it a 2-to-1 ratio based on some prior Superior Court precedent in business tort cases, which set forth a potential basis for this court.
Okay, thank you very much.
Good argument, counsel. Thank you.
Good morning. I'm Ken Apricano from the firm of Harder, Seacrest, and Emery. On behalf of Plaintiff Appellee, the Bert Company doing business as Northwest Insurance Services. We are here to discuss whether the punitive damages are grossly excessive in this case. And I push this in this case. I can see the court has done this, and I've done it extensively. All the cases you read in this area clearly show appropriately the elasticity of how you apply all of these standards to the facts of the particular case. And let's just start. I'm not going to follow my outline here. I'm going to jump into where a lot of some of the questions left off. What is substantial? I read all the new cases cited by appellants. I read all the ones, of course, that we cited, and they all contradict. We have lots of cases saying 250 is not substantial. They have lots of cases saying that it is. But if you read them all, you see that those determinations are made in the context of the particular facts. So under a Fair Credit Reporting Act case, when a bank accidentally or misstates a record, a credit report on someone and doesn't fix it in time so that there's some reprehensible conduct there to justify it, suddenly $50,000 seems substantial, right? Because in that kind of a case, in one of the cases, the librarians were discriminated against, inappropriate discrimination by all means, but they didn't lose their jobs. They didn't get paid less. They got $500,000 each. Court said that's substantial. Our case, and this goes to the vulnerability factor as well as the substantial aspect that we're considering. It's said here that we're not vulnerable because we were strong economically before, we were strong afterwards. And if you look at the cases, it's were you vulnerable to the particular attack brought by the defendants? Again, going back to the facts of the case. In Planned Parenthood, they said that doctors make a lot of money, we know that, but they were vulnerable because the attack was against their professions. Okay? And we cited Flying Fish for this, and this idea that looking at the defendant's actions, were you vulnerable to it? Well, clearly, we were vulnerable to it because we are a small business. I mean, $9 million of revenue is not that much money. You have to look at it as a subsidiary, a final entity, and we had a certain number of people that could handle the profitable P&C business. And armed with the knowledge that Turk gave them as the head of that group, they were able to take every single person who could handle the significant work that we had. And they also took the person we were hiring to help that group become more successful. And they knew that one of the top account executives, Melissa Wernicke, was out on maternity leave. So they knew that we couldn't handle that business if they took everybody at once. Okay, that's why when Will Collins said, I don't want to leave I want to leave earlier, I can't stand, I want to leave earlier. And Mr. Mushnak says, we're not going to drip, drip, drip out of here. You can't leave before. You're not going to drip, drip, drip out of here. We're going to hit them like a tidal wave. The concept was to take everybody that could do the work so that the work couldn't be done. Now, their brief says, but look, how you didn't lose anything. Not true. That's a misstatement of the record. Our controller testified that we lost to First National before the injunction was granted, $500,000 of annual recurring revenue. As the time went on, additional work went over to First National for a total of $606,000 of recurring revenue lost. We then lost $350,000 of recurring revenue to other competitors because we just weren't suited. We worked hard. Mr. Bert brought in an hourly consultant who knew this work to help. We were able to recruit and pay someone to bring somebody in. Yes, sorry.
I was wondering, did the jury hear evidence about the potential economic loss Northwest would have faced if the plan succeeded?
Yes. The $9.4 million came from testimony from Doug Bert. It does relate to gross revenue. More importantly, however, we put in the pro forma analyses done by First National. Okay? So companies like this don't just, oh, we like this person, let's hire them. They do analysis. They guaranteed salaries of $300,000 to Turk, $200,000 to Collins, and they did an economic analysis of how much business would come over from Northwest to First National, and if it would justify it. They projected that $1.1 million of annual recurring revenue would come in, and that was based only upon Collins, Turk, and Jamie Haynes coming, okay? The email said that there were supposed to be 2 waves. The first wave of PC people, in a couple of weeks there'd be 4 more people coming, which was the employee benefits group, but that didn't occur. So all that evidence was before them. Now, economically, our expert did an analysis saying, if you were to buy, using the pro forma assumptions of the done by the CFO of, or I don't know if it was a CFO or assistant CFO of First National Bank, Ralph Fuchs, what would it be? What would you have to pay for that standalone business of what they were trying to take? And he gave the value at $5.3 million, and it's in the record. It's cited in our brief. So you know we're in the below 1-to-1 ratio, or 0.5 to 1 already when we start looking at the potential harm. On that point, okay, we're sort of close to the substantiality. I guess I was trying to say here was even without potential harm. I don't think this compensatory damage award was substantial in this fact pattern. I think it was actually way too low because it looked at a percentage, a lesser percentage of the total revenue lost rather than a multiple of that reoccurring revenue, which is the way accepted accounting experts would present it. So in this case, that's not a substantial award. Furthermore, the whole word of substantiality, you know, the 1-to-1, that shows up when you've got $100 million. You always see that in those cases where there's $100 million compensatory damages and the courts are going, well, maybe we want to keep it in that range. However, they of course have gone well outside of it many times. You see that in Ingham versus Johnson & Johnson, which is a good prelude, of course, to corporate consolidation, and I'm happy to go for, I'm trying to hit some of the issues that were discussed. In Johnson & Johnson, you had a parent and a subsidiary corporation. One was hit for $900 million, the other was hit for $700 million, and they did not consolidate them as family members. They judged it independently on its own. Each of the cases that they rely upon for this idea of corporate consolidation are cases where you couldn't distinguish between the actions of one or another of the entities. Sometimes because it was just maybe one actor on a very small, you know, if a single person owns 2 corporations, a parent and a subsidiary, they're acting, how do you know which one they're acting on behalf of? There were a few statements I disagree with, strongly disagree with the idea that this case was tried as a corporate family case. Not true. Boy, it would have been a lot easier. I tried the case. It would have been a lot easier. We had to show wrongdoing by each of the corporate entities. We showed separate officers for each of the entities and participation in wrongful actions by each of them. And the court picked that up in some of the comments. Mr. Moorhead is one of the top officers in the whole bank, and he's approving every single thing. He's fully aware of what's going on, and he's acting on behalf of the bank. The CFO person acting on behalf of the bank. The HR people who were involved in, and we're actually kind of bragging about their involvement through the whole thing. Susan Lorenz is from F&B Corp. So there were separate actions by each of them, and we tried it that way. And that's how the jury was charged. I mean, I don't know how we say that this was always a corporate family case. It wasn't.
Counsel, could I,
Sure.
ask you on that? So if we're searching for, any kind of standard on that front, would it be sufficient disincentive for the plaintiff to scattershot name every affiliate in a corporate family, to resort to the trial judge's non-suit or directed verdict power? In other words, if it gets to the jury, and the jury, and there's some articulable basis for the jury to award damages if it chooses against defendants A, B, C, D, E, F. From the perspective of searching for a legal standard here, is it sufficient to say that the trial judge can take away the opportunity to award punitives against G, H, and I because there's no individualized evidence in the case against them? Or do we need to articulate some more defined or universal standard?
I think the principles that are involved in our trial system more than ably protect against that type of abuse. You have summary judgment. You have, in this case, let's just take this case, okay? Summary judgment on whether or not there was sufficient evidence to keep all three corporate defendants in the case. We survived that motion, and they were kept in the case. At the close of our proof, there was a motion for directed verdict or non-suit with regard to many issues, including whether there was enough proof as against F&B Bank and F&C Corp to keep them in the case. Motions as to whether or not the punitive damages should be dropped before they're given to the jury as against any of the individual defendants, and they were dropped as against a couple of the individuals, okay? So like Mr. McDonald, it was dropped, I believe, I don't remember the others, but the point is that was decided by the judge before you went to the jury, and the finding was there was sufficient evidence to present it to the jury based upon the individual participation of each corporate entity. So if I went through and listed, who knows how many entities they have, but 42 subsidiaries, they wouldn't get to the jury. Only the ones where there were actors participating. And frankly, the deceptive conduct, the malicious conduct is worse in this scenario. If this had just been Mr. Muchnock in a subsidiary doing insurance work, maybe outside of the obvious, the understanding of the higher ups in this multi-billion-dollar publicly traded bank, it would be a little different. You could say, well, we had a rogue actor, we had a rogue entity. That's not what happened here. I'm sorry, that's not what happened. This was approved from start to finish by the higher ups in this organization, even to the point of trying to get the head of the whole agency, Doug Bert, involved, which, by the way, he wasn't solicited. He didn't know about this. This was the First National wanted Doug Bert to go in and meet with the CEO, top dog of the entire huge bank. So this was all the way through, and it does make it worse. It does make it worse. You tell me that the top officer of a bank of this size and the top HR people of an organization this size don't understand the nature of breach of fiduciary duty of an employee, that employee, while still working at Northwest, isn't supposed to be soliciting his fellow employees to go off on this venture to frankly destroy, if not all, at least a good portion of their current employer. It's obviously a reprehensible conduct. Ratios, why are we right? I think we have it, but let's think about it from a couple of other perspectives. Unless you want me to, can I go to ratios, our favorite subject?
Surely, go ahead.
Let's think about it. Due process is an individual right. This isn't a collective right of all the defendants together. It's an individual right for each defendant. They're supposed to be tested on and that's what the jury was charged. Consider their independent, reprehensible conduct, give a separate award. And as someone noted, they did give separate awards, for much more for Muchnock and First National Insurance Agency, I should say, the insurance agency. It's an individual right. You don't look at it collectively. You have to look at it independently. Now, let's take compensatory damages. The principle behind joint and several liability is that each defendant is fully liable for the amount because they participated as co-tortfeasors in one indivisible harm, injury, one indivisible injury. That's the harm they caused. So when you look at Gore and State Farm and they say you compare punitive damages to the harm suffered by the plaintiff. Well, the harm suffered by the plaintiff, the highest amount awarded was $250,000. Sometimes they talk about the harm caused by the defendant. Well, each defendant caused the full amount of the harm. That's just the way joint and several liability work. They talk about contribution, but it's not related to the tort. That's a right as between co-tortfeasors that relates to an equitable doctrine that arises if and only if one pays more of the judgment than the court thinks is fair. A wholly separate concept. And in Pennsylvania, as you know, we still have joint and several liability for intentional tortfeasors in cases such as this. Now, there's this discussion of, well, if you had 10 defendants, it's going to get too high. And he brought up Planned Parenthood. Well, by using 14 defendants there, they got, if you were to take their approach, it was 124 to 1 ratio for some of the doctors, if you did it jointly. And that's not our case, obviously, not our case. But let's think about it from a principle standpoint. Is the fact that the plaintiff gets too much by having too many defendants really the issue in federal due process? Maybe it should be an issue for the legislature. Maybe it should be an issue under state law. But under federal due process, we are concerned with whether or not the defendant was penalized too much. It was grossly excessive for their conduct, right? For what they participated in. And it's the question of multiply, and that's too many times. Well, that relates to how much the plaintiff got, which is not the question before us. The question before us is, did these awards properly punish and deter the individual defendant actions? And under that analysis, doing the per defendant ratio as we calculate it is the appropriate one. As to your idea that these guidelines, it's so interesting to see how the Supreme Court says it. They said, if you did not meet any of the first guideposts, number one guideposts, the constitutionality would be suspect. I never say it's unconstitutional. It's always suspect. If the ratio exceeds a double-digit ratio to a substantial degree, the award may be suspect. It doesn't say you can't do it. It means that court should take a good look at it. That's what it means, right? The third prong really doesn't apply here because there are no civil penalties.
Counsel,
yeah.
if I might, aren't we trying to determine in this analysis, bottom line, was this a rogue jury? Did they do something here that has no support under the facts, no support under the evidence that was presented, and did something to, quote unquote, make a statement, as opposed to justly call into question the reprehensibility of the conduct and to deter it in the future?
It's one of the, sure, that's an excellent way to look at it. And I would say this, in their reply brief, they say, oh, myth versus reality on the factual issues. First, I don't agree that a de novo review means that you have to accept their version of the facts equally to ours. You consider, unless it's clearly erroneous, you assume that disputed issues were interpreted as against the defendants by the jury, and that's proper. But to your point, let's think about this. These facts were presented, and a unanimous jury made this finding. On the post-trial motions, a judge wrote a lengthy opinion laying out the facts that supported the jury's finding. Now we go to the Superior Court, and this is a remarkable decision. If you read the factual recitation of the Superior Court's decision, and you were to compare it to our brief, they did their own independent independent record review. I didn't have the word, I couldn't meet the word limits to put that many facts in our brief, okay? This was an independent review by the judges and clerks of the Superior Court, laying out an amazing record of the facts that supported this jury's finding. And I don't want to spend the time arguing the facts unless it's a question of the judge, but read that if you have any question about a rogue jury. This was not a rogue jury.
Counsel,
Yes.
just one quick question.
Yep.
How do you take into account, or what's your argument with regard to the ratio taking into consideration the egregiousness of the misconduct? Does it?
Yeah, definitely. I've seen definitely cases that'll say you have to consider the reprehensibility of the conduct in determining the appropriate ratio. So it certainly could go up under that circumstance. Well, you know, this is a little pet peeve of mine when people say 9-to-1 versus a double-digit ratio. Okay, a double-digit ratio is 10-to-1. If you take Turk's $300,000 out of the punitive award, you're talking, even on their approach to things, 10-to-1. Okay, Turk's not supposed to be. He wasn't even okay. But I'm the corporate consolidation approach, right? But 10-to-1 ratio is 1 penny in excess of a single-digit ratio, because 9.999 to 1 is still a single-digit ratio. I saw some cases that said that. I don't know where this whole 9-to-1 thing came from, but there is no way you could say that 10-to-1 is substantially in excess of a single-digit ratio. And frankly, there is the 11.4 ratio. If we look at the cases, they're so frequently 200-to-1 when there's concern about these things.
All right, does anyone have any final questions? You want to sum up, Mr. Africano?
I think I probably already have, but thank you. You know, obviously, there is a certain sense that you get from reading each of the cases cited. So many of the cases in this area where you do kind of know it when you see it. There's a certain gut that something is wrong here. What would be wrong here would be for First National to pay $250 in compensatory damages and $250 in punitive damages. That would be a gross injustice. The jury did a good job, and the Superior Court did an amazing. All the way through, justice has been delivered, and there is nothing grossly excessive about this award.
Thank you. Before you sit down, Mr. Africano, did you introduce your co-counsel to the court?
Steve Del Sol is our local counsel and an important part of the brief writing team, and Chloe McDonald is my associate.
I'm sorry, what was your name again?
Chloe McDonald, who has been with us from day one in this case and was at the trial, and my right-hand person.
Great.
Did she participate in questioning witnesses?
I wish she had, but I think she was only a second-year attorney at that point, and we
Well,
had.
it doesn't mean she couldn't question witnesses.
I should have, Your Honor. I look at.
Maybe in the.
Now I know. I don't know if she wanted to tell you that is truth. I don't know.
Does
Did
now,
she?
she says.
does.
Okay.
She wants now. Now she does.
All right, thank you all. That was very well argued.
Very nice.
Commonwealth, Pennsylvania versus Christopher Albert Koger, representing Commonwealth, Mr. John Friedman, representing Mr. Koger, Mr. Indian Lion.
Morning, Mr. Friedman.
Good morning, Your Honor.
In this case, a parolee challenges the revocation of his parole leading to his resentencing. We're asked to decide whether our decision in Commonwealth versus Foster, which held that a probation violation determination must be based on conditions set by the sentencing court, applies to a parole violation as the Superior Court found in granting relief to the parolee.
Thank you, Madam Chief Justice. Fellow justices, may it please the court, John Friedman, Deputy District Attorney, Washington County, on behalf of the appellant, the Commonwealth of Pennsylvania. The issue in this case is whether the Superior Court erred by improperly expanding Section 9754 of the Judicial Code related to probation, and improperly expanded this court's 2019 holding in Commonwealth versus Foster by applying it also to parole, thus requiring parole conditions to be imposed by the court at the time of sentencing. The Superior Court did this by adding in "and parole" in brackets into 9754's statutory language and into quotations from this court's Foster decision. The Superior Court was wrong and erroneous for two reasons. One, 9754 and this court's opinion in Foster are clear. They relate only to probation conditions. Foster was a statutory interpretation case and dealt solely with Section 9754 and probation. Second, the Superior Court's addition of that language to 9754, that phrase "and parole," and to this court's decision in Foster, ignores the statutory language that does exist that speaks to parole, its authority, and the conditions that may be attached, both within the Sentencing Code, Chapter 97, and within the Parole Code, Chapter 61. As to the waiver argument, Mr. Koger raises two challenges, one waiver and one as to mootness. As to waiver, the Commonwealth could not have raised this issue sooner than its request for re-argument and the appeal to this court, because the Superior Court adding in that language was the first chance that 9754 had been changed in this way and Foster had been changed in this way. Second, as to mootness, one, Mr. Koger is still on probation as we speak. I think he has a couple more months. I think it's up in January or so. So he could possibly violate his probation, could be resentenced and subject to parole. Second, and more broadly, as we sit here, there are thousands of individuals in Pennsylvania on parole. And those thousands of individuals may or may not have had conditions set by the court at sentencing, but certainly if they are on state parole, they would have had conditions set by the state parole board at the time of their sentencing. If the Superior Court's decision in Koger were to stand, those violations, any violations of that parole, could not have happened, because if they are based only on the conditions set by the parole board, the Superior Court is saying that the trial court would have no, or the parole board would have no authority to violate that parole. This would affect those thousands, and both good and bad. And let's look at it this way. If the Koger decision, the Superior Court says that parole conditions have to be imposed at the time of sentence. With probation conditions, there's no question. Statute is clear. With parole conditions, if they are set, have to be set by the court, the sentencing court, at the time of sentence. Those conditions can't change. Although 9771 permits probation conditions to be amended by the court. There is no equivalent under the statute for parole conditions to be changed. And we can envision a number of circumstances where a change in circumstances of an offender work both ways. For example.
Commonwealth.
Yes.
Commonwealth, question. If I'm a trial judge and I sentence someone to a state hit, and I give them 3 to 6 followed by 4 years probation.
Yes.
They go up to state. They are released on parole.
Yes.
The conditions provided by the state parole board are not part of my record.
Correct.
How am I to violate them for a condition that's not part of my record?
How are you to violate them?
It comes back as a VOP.
If it's a parole violation, if it's a 3 to 6 and a state parole violation,
It goes to the
it
parole.
goes to the state parole board.
Correct.
So you would not have, you as the trial judge in that circumstance would not have the authority to violate. But if we are reading Koger, what the Superior Court said in Koger, if you, the trial judge, at the time you send them up 3 to 6, do not impose conditions, then they cannot be violated. The conditions afterwards by the parole board may be nice guidelines, guideposts for conduct. But Koger says conditions of probation and parole have to be imposed at the time of sentencing.
Well, but I'm not sure I'm following how you responded to Justice Doherty.
Okay.
Justice Doherty's hypothetical was sending the person on to state time. 3 to 6.
Yes.
Over the range at which the common pleas court, the sentencing court has jurisdiction. 3 to 6.
Correct.
Parole goes to, as a matter of grace, to the Board of Probation and Parole.
Correct.
They're the ones that set the terms at the time parole is granted, and it's on the record, it's in the file. And if there is a violation of that, it's the Probation and Parole Board that issues the detainer and basically revokes the parole. Or not, maybe they don't.
Right.
Right? What we're talking about here, where I think Koger is they're saying there has to be something similar that happens when there's a county parole. The Board of Probation and Parole, they have to provide conditions at the time they put you out on parole, and the trial court, if they are going to put you out of parole when you're on a county sentence, they too have to give you conditions at the time they put you out on parole. I know that they said sentencing too. That doesn't make a lot of sense to me unless they're sentencing you and you are immediately eligible for parole because you had time served. But what's wrong with that? What's wrong with saying, in order to tell a person put out on parole what the conditions are, a county judge must do exactly what the Board of Probation does on the state level and say, here are your conditions of your parole?
The statute, well, one, the statute doesn't say that, but two, that's not what Koger says. And I understand your concern, and I think the problem is what the Superior Court said in Koger changes what we're talking about.
But it doesn't affect what happens to a state inmate.
It could. If the Superior Court is being reads correctly, they're saying conditions of conditions of probation and parole must be imposed at the time of sentence.
I have some concerns about the language that the Superior Court, so I'm kind of trying to cut to the nut of it, which is here you have a criminal that was doing county time or was sentenced to county time, had time served, and at the time of sentencing, just happens that sometimes this happens, at the time of sentencing was immediately eligible for parole, and the sentencing judge paroled him. What is wrong with, at that point in time, the sentencing judge saying, here are your conditions of parole, similar to how the Board of Probation and Parole does it?
There was nothing wrong in that circumstance, but that's a very small circumstance. Not everyone will be eligible for parole necessarily at the time of sentence. It would be for a time served. So for those time served portions, then there's not an issue because that would be the time of sentence.
Right. So then, in the other circumstance, under the statute, there has to be a hearing where the person is brought back before a judge to determine whether the judge wants to parole the person. And there, the court gets to make such order as it deems just and proper. Why isn't that the authority at that point in time for the trial court judge to say, I'm going to parole you and here are your conditions?
Well, that can be at the authority. Even though, now I don't know how many counties necessarily hold those parole hearings. I know the statute requires it. Some counties do self-completing orders.
We're gonna presume that counties are following the law.
Correct.
Okay.
In those circumstances, any order that's just and proper would or could include those probation terms. Or, excuse me,
Parole.
include those parole terms. Thank you. Could include those parole terms. In the issue where those hearings aren't necessarily held, or where an issue comes up afterwards, a supervising parole officer has the tightest, most closest connection to his offender, even closer than the court. And that parole officer may know what is necessary in those circumstances for that offender to live his best life, to reassimilate into the community, to be rehabilitated. And in those circumstances, unless the court at the time of parole, at that hearing, is going to give broad conditions, be law-abiding, be of good behavior, the probation officer, parole officer, county probation parole officer, will have the closest connection to know what is required of that offender.
But again, I don't want to look at what may or may not be happening out in the counties. I want to look at what the law requires.
Certainly.
Why doesn't it make sense when the defendant is hauled into court at the hearing that the statute requires and the judge makes a determination on whether to parole the person? You don't have a county probation and parole officer there who makes suggestions on conditions, and there's sort of a colloquy. Have you confirmed, counsel? Do you agree with these are the conditions that you're going to serve on your parole? Yes, I do, Your Honor. All in open court, and it's done. That seems to me how the statute envisions this happening.
And I agree that would be how the statute envisions it happening. One, I think the question is, does that happen in every case? And two, going back to the language of Koger, which I think both you and I agree.
I have some concerns about the language of Coger. I'm just trying to address the issue of it seems to me that a defendant put out on parole should know the conditions of the parole.
Absolutely, there's no question.
And it seems to me that for county parole, the obligation to provide that information is with the trial judge at the time of the hearing that the person is put out on parole.
I would agree with that.
Okay, so we're here because apparently, I guess, some counties aren't following what the statute says.
I think it's, in some cases, some counties aren't following what the statute says, and we're also here because, again, the Superior Court's language, what they did in Koger is way too broad for what the statutes say.
Counsel, we have a different statute now, do we not? You have to help me with this. Has the statute been changed?
Regarding,
Parole? At the time that this case came up, the statute provided for county sentences that the trial court would set the terms of parole, correct?
correct.
Under the new statute, are even those county sentences controlled by the Bureau of Probation and Parole?
Not unless they're requested to. So all county parole defaults to the county judge, unless the judge specifically requests the State Board of Probation and Parole to supervise. And, not to add another wrinkle, for some offenses, even more than 2 years, which normally would be state, if they're being served in the county, up to 5 years, the judge, sentencing judge, could still have parole authority.
Yeah, so if I could just follow, because Koger's arguing that you're saying the parole board was statutorily mandated to impose the conditions of parole here, but that's not how I understand your argument, right? I mean, you concede that they had no authority here because it's a county sentence, right?
Correct. And I think Mr. Koger misperceives a little bit my argument. I think, Justice Wecht, you've identified it. There are two separate parole tracks in Pennsylvania. If we read what the Superior Court said in Koger, it affects both tracks. And that's the point that the Commonwealth was making.
So are you fine if we close one track and the other track is fine?
Meaning the state track?
Yeah.
If this, I think that statutorily, the state track has to be fine. Right. Unless the Superior, I mean, looking at the parole statutes regarding state parole, I don't think that the Koger decision can apply. Right. Regarding county parole, I think that's still an open question. And I think, as you said, if we look at 9776, which sets forth the parole procedure for the hearing and then the order that's just and proper, that can be the time for the court to set those conditions.
So you would want us to reverse Koger only to the extent, well, I assume you want us to reverse it entirely, but your double, not your home run, would be we limit Koger to county sentences, county paroles.
My argument would be, and my request would be, that Koger be overturned completely as regards to parole. If there is any restriction, it cannot apply to states. So it would be open as to, and we'll, again, revert back to the statutes that do exist with regard to county parole, and that's 9776.
But it's undisputed that the trial judge here at the time of parole did not set conditions.
Correct. That's not contested. That's correct.
Okay, Mr. Friedman, anything else?
No, thank you, judges and justices. Excuse me. Thank you, justices, and I appreciate your time.
Thank you. Let's hear from the appellee, Mr. Lyon.
Good morning, Your Honors. Tim Lyon on behalf of the Appellee, Christopher Koger. And I think maybe the easiest way to cut to the chase is that Koger is an 8 to 23-month sentence, so it's a less than 2-year sentence. And I think read in that context, what it's saying is makes sense, that this is a situation where it is county parole, it is the sentencing judge that has the authority and the jurisdiction to impose the conditions of parole.
But not the mandate. Now, I mean, that's Where are you getting that mandate? The cases you cite, including Foster, they're all probation revocations.
So the mandate comes from 9775, 9776, and even, I believe, this court's Rule 708, which talks about it's the sentencing court, it's the trial court in a sentence of less than 2 years that determines whether or not there's been a revocation, has a hearing, looks at the evidence. All of this authority is falling in the county court of common pleas and at the county sentencing judge. And it's when you get a sentence over 2 years that the board is involved. And so, for example, we've got Justice Doherty's question about how could you, as the trial judge, violate someone on a 3 to 6 year sentence? And you can't, because it's Rule 708. The comment to Rule 708 makes it clear that it only applies when there's a less than 2 year sentence. We've got even Deputy Friedman's comment about there's, supervision can go to the board. And that's right, it's supervision. Conditions of supervision can go to the board. But for a less than 2 year sentence, conditions of parole don't go to the board. They stay with the county court of common pleas. And that's what Koger is. It's an 8 to 23 month sentence. And so in the context of what Koger is about, we're in 9775, 9776, Rule 708. The authority is with the court of common pleas, and it's not with the board.
But the argument from authority is different than the argument for a mandate, right? I mean, you go a step further, and the Superior Court went a step further, right, to say that's mandated.
And forgive me for responding with a question, but mandated that the sentencing court has to impose the conditions?
Yes, must.
And
There's no statute. You'd agree there's no statute that says it must do that, right?
there's no statute that uses those words, but there's no statute that gives the board any authority to do that. The authority is within the Court of Common Pleas when the sentence is less than 2 years. So
But
if
she imposes no specific conditions, where's the error? Other than arguing that we should treat it just like probation.
If she imposes no specific conditions, then the error occurs when she finds a violation of a condition that was not imposed, and that's what happened here. So had there not been a finding of a violation, which is why I would dispute Mr. Friedman's request for relief that you overturn everything, because you still can't get around that there was no condition imposed and there was no evidence sufficient to support the violation of a non-existent condition.
Let me take a spin on that. Your response to Justice Wecht would be, there is no mandate that a trial court judge impose conditions on parole. However, if conditions on parole are going to be imposed, that can be enforceable through a revocation. They have to be put in place by the trial court at the time of parole.
In a less than 2 year sentence.
I presume that in my answer.
Yes, yes, Mr. Justice, that's correct.
So even if we take the route suggested by the Commonwealth to narrow the Koger holding and have it apply only to county parole, your client still prevails?
I believe so, yes. And I think, there are some cases, and they're cited in my brief, but there are cases where it's less than 2 year sentences. The sentencing judge is imposing conditions of parole, and then there's disputes about whether or not the conditions imposed are appropriate. In one instance, I believe the Mitchell case, there was a finding of a violation of a condition, and the case came up at that point, so it wasn't a direct appeal from a judgment of sentence. But in those situations, there's no discussion in the cases about, hey, this trial judge didn't have the authority to enter these conditions.
Does it matter whether the violation is a technical violation? You didn't report, you didn't check in, versus a commission of a new crime?
So certainly for probation it would. For parole, I'm not sure that I've seen case law on that as an issue. So I guess I would say I would prefer that it that it not matter for purposes of Mr. Koger, but I'm not aware of case law on that.
I think that the record in this case is that the violation wasn't of a technical nature, but was the commission of a pretty serious felony.
I disagree with that, Your Honor. He was not charged with a new crime. The violations that were found, I believe, were engaging in assaultive behavior, and I believe an assault, like verbally. He was communicating harshly with one of the probation officers. Correct.
With the CO.
And there was testimony about Mr. Koger having some inappropriate material on his cell phone, but there was no substantiation for that. And so the court found, I believe, in its revocation order, it specifically says technical violations of probation and parole.
Well, but does raise the questions, though, about, because maybe this is where the District Attorneys Association might have a concern, is if we don't have, it just goes to Justice Mundy's question, should we assume that there are, in every parole, that there are certain terms? For example, should we assume as a matter of law when someone gets the grace of parole that they're not going to reoffend while they're out on parole? And is it fair to assume that is a condition of every parole?
I think you could make that assumption. I'm not, again, aware of case law that supports that, but
How about Foster?
it's certainly in
How about
Foster,
Foster?
right?
I mean, yeah, there is case law.
On the probation side of things, it is very clear that
Even if not stated as a condition, the commission of a crime is going to
it's an
be
implicit
problematic.
condition, correct?
Correct.
And then could you also say that it should be implicit that maintaining communication with your parole officer could be an implicit term in terms of your parole that does not have to be announced specifically by the trial court when trial court paroles you?
So the parole statute requires that at parole in the less than 2-year context,
Right.
that the court appoint the probation office to act as the parole officer, and I think that would be part of that process, that they're the parole officer or the probation officer who's functioning in that capacity.
So then so I guess I'm trying to figure out, if we assume for a moment that it's implicit in a parole determination by the trial court that you will not reoffend while on parole, it's implicit that you will cooperate with the parole officer in terms of reporting regularly. What are the types of conditions that you argue have to be on the record in order to be enforceable?
Well, I don't even know that I think you could find that you have to report regularly, but there's non-reporting probation. I think there can be non-reporting parole. I mean, if that's the way that they go to set it up, my position would be it would just be reoffending, and otherwise the court needs to make clear.
Which your client did.
He did not. He was not charged with.
Oh, he was not charged.
He was not charged with a new offense here.
I still just want to come back to it seems you want us to validate what appears to be a conflating by the Superior Court of the probation and parole statutes. I mean, in Foster, we were interpreting an unambiguous statute regarding probation. Don't we have a different landscape here from a statutory perspective?
I think in the context, again, of the less than 2-year sentence, we're in the right place. And I think when it's read that way, we're talking about a case where Koger involved both probation and parole revocations, and the court was explaining that in this less than 2-year context, you have both. Everything is governed in that context by the trial court and by the sentencing court. And so that in that system, it's the sentencing court has to impose the conditions of parole, the sentencing court has to impose the conditions of probation, and the cite to Foster and to 9754, they're C sites. They're not saying that's what Foster.
Counsel, post-Koger, the amendment to the definition section, 6106, now answers this question. Would you agree? That now that the conditions of supervision include not only judicially imposed, but board imposed. So therefore, while it was not in effect in 2019 when this case happened, as we sit today, your argument carries no weight based upon the definition of 6106. So share with me. Go ahead.
May I grab? I just make sure that I have.
So share with me, what are you arguing for? I could just share with, let me read.
Yeah, I did not bring that, so I.
No worry. In 2019, they amended the definition section, and in it, the new definition of conditions of supervision is any term or condition of the offender's supervision, whether imposed by the court, the department, or an agent, or promulgated by the boards as a regulation including compliance with all the requirements with federal, state, and local law. And I believe that amendment was to correct this issue. So now that we have we have it, that now saying that any condition imposed by either the court or the board is deemed capable of being violated, whether it's specified by the court or not. So how do you argue that we're not to take in 6106 definition, which is unambiguous, to reach your result?
It appeared as if the reference was to condition of supervision, and we're talking about the condition of parole. And so if the court looks at its Elliott decision, which was in the probation context.
Parole supervision, correct? Just like probation. Are now you defining, now are you providing the term supervision to be exclusively within the realm of probation? Supervision means I'm watching you. That's it. Whether it's parole or probation.
So I believe maybe this is going to get us there. Elliott stands for the idea that the court imposes the condition of probation. And the court is the only one who has the authority to impose the condition of probation. But the board can have conditions of supervision.
An agent in this new definition, unfortunately I don't have it, is a state parole agent appointed by the department. So the term agent means state parole, which means state parole can put on conditions for which they will supervise, which would be parole supervision.
And what I'm trying to distinguish is that it would be supervision, under the idea that supervision is different than the actual condition or term of parole. And so it's designed to elaborate on one of the parole conditions or to...
The caption is conditions of supervision. So, I mean, you're at a distinct disadvantage because you don't have the statute before you, but it's conditions of supervision, which is specifically the issue that's before us today. So I guess, I don't know whether this should be IG'd.
But can I follow up on that? Because this is the question I tried to ask your opposing counsel, and he told me that I was wrong, which I probably was. But let me see if I could follow up on this a little bit. What Justice Dougherty is talking about is a statute that came into effect after our Foster decision and after your client was subjected to the revocation of parole, correct? You are before us here arguing the law as it existed when your client was subjected to revocation, correct?
Correct.
Okay, so, I mean, the fact that you don't have the new statute with you, I guess I would understand that. And it does get confusing because the Commonwealth in their brief at certain times argued the new statute and at other times argued the statute in existence in the case that we have before us. So, I mean, the question of law that we have here today is a question that's not going to come up under the new statute, assuming Justice Dougherty's interpretation is correct. We don't have to decide that today. But, I mean, for the sake of what we're doing here, and I happen to think his reading is accurate, but it doesn't really make any difference to the outcome of your case. You're saying under the rules in existence at the time that your client went through the criminal justice process, there's nothing that mandated the common police court to enter conditions of parole. Nothing that mandated that. But then if you're going to revoke, there's no condition to base a revocation on. Am I correct?
That's correct.
Okay.
And I would also.
And this statute would fix that problem.
The statute has fixed it.
The statute would fix that problem, but that was not the statute in effect when your client went through the process and the Superior Court decided this case. I'm going through this for the purposes of my clarity about what we're deciding. I mean, I view this as a gap case, a case that came up after Foster, before the new statute came into effect. And now we're in a new legal landscape.
And I would also just, there is this court's decision in Elliott that draws distinctions between conditions of, and it was a probation case, but conditions of probation versus conditions of supervision. So to the extent
Okay,
that.
but that would be, that argument would go to what the new statute
Correct.
does,
And
not what this case does.
And
I thought we agreed, perhaps it was opposing counsel, that the amendment wouldn't apply because we're talking here about county time. So which is it? In other words, the intervening amendment didn't apply to county sentences, I thought.
No.
Is
What
that
he
not
just read,
correct?
it does apply to county sentences.
Well, that's what I'm trying to clear up, because I guess I'm in a different understanding, because the amendment that occurred, I thought was only with regard to state parole. So which is it in your understanding?
And I apologize again for not having it in front of me, but my understanding is that the county sentences, the less than 2-year sentences, are controlled by the sentencing judge and the trial judge, and that the board doesn't have authority to impose conditions of parole. The board could have authority to supervise, if it's given that authority, by the court. By the court.
I'm sorry.
The amendments, and again, we'll probably have a nice discussion about this outside of your present. It'll be a very nice conversation about whether the Chapter 61 amendments do anything to alter county parole and probation. I would note Section 6134 talks about the involvement of the sentencing court in suggesting terms of parole to the Board of Probation and Parole. And those suggestions are advisory only. It's actually the board, when you're dealing with a sentence of over 2 years, it's the state Board of Probation and Parole that makes those calls. And under 2 years, it's the county trial court judge that makes those calls.
Correct, and that's also my understanding.
Okay, Mr. Lyon, do you want to sum up for us?
My position, I hope I made it clear, is that the court shouldn't be overruling the result that was reached in Foster, and that Foster, in context, makes sense when you're dealing with a less than 2-year sentence. It's there that the trial court has the authority and the jurisdiction, and it's only when you get to 2 or more year sentences that the board gets involved.
Okay, thank you both.
Thank you. Commonwealth of Pennsylvania versus Damien
No, I'm good.
Yeah, please.
Mr. Green, Mr. David Kiss.
You need something, water or something?
Good, thanks. Okay, in this case, Damien Green, a juvenile, filed a petition for decertification of his criminal case from adult to juvenile court. Both Section 6322 of Title 42 of our statutes and Rule 597 of the Rules of Criminal Procedure require a trial court to make a decision on a petition for decertification within 20 days, or the petition will be denied by operation of law. The trial court in this case issued its order granting Green's petition after 50 days had passed. We are asked to consider whether the trial court's order issued outside the 20-day period was a legal nullity, or whether exceptions to the 20-day rule may be recognized in the interest of justice. Please proceed.
Thank you. Good morning, Chief Justice Todd, honorable justices. Daniel J. Kiss on behalf of Mr. Green. As an aside, prior to getting to my argument, it's almost apropos that this is one of the cases that is first heard after the passing of Chief Justice Bert. Given his history, as Your Honor outlined this morning, this would have been of immense interest to him, I would imagine. And to the extent we believe in such things, I would suspect that he has taken a recess in his celestial docket to listen a little closely to the arguments of counsel this morning. We have argued in our brief here in lower really two separate remedies available to Mr. Green, one being a legal theory basis, as well as one being from a more statutorily type basis. They intertwine with each other to a large degree, and while I use the word absurd in my brief, I think that Justice Donoghue was actually correct, and I should have used the Pennsylvania words, shock the conscious. And from our position, and it's our contention, that Mr. Green came through this process meeting every deadline, do everything correctly, and but for the action of a court that he had no control over, he now finds himself facing a substantially different outcome than what the court itself found by evaluating the facts before it and evaluating the expert testimony that was presented to it. So it leads us to the situation where we have argued, using either Justice Donoghue's words of shocking the conscious or our language of absurd, that the outcome that created here is an absurd outcome. Now, while I recognize that when you look at the juvenile handbook and that the reason for putting in strict deadlines is to ensure that a juvenile case moves quicker, because as the amicus brief stated, and I totally agree with, we do treat juveniles different. Juveniles are not the same as adults. They come from a different place. They come from a different perspective. They are not fully formed adults yet. So our system treats them in a different manner. However, this statute and this rule has the effect of removing the ability for the juvenile to fully litigate a matter. What do I mean by that? If a trial court issues an order, whatever that order is, either in favor of decertification or against it, within the time frame, both parties would have an opportunity at some point in the matter to appeal that order on its merits.
Counsel, from a very procedural position, all that we have here is that the defendant, your client, is to face trial in the adult court. How is it that you're asking us to vacate a plain reading of the statute indicating that it's denied by operation of law should the judge not do it? Is this not better suited for post-trial motions, whether it's abuse of discretion or even if this should result in conviction, that this could be corrected in a sentence appropriate, say maximum, as we were talking about, state 2 to 4 years, since we all know juvenile law, I could place you for 4 years or till you're 21, whichever comes first.
Yeah.
And he was 17 at the commission, correct?
He was 15 at the commission.
15.
Yeah, he's almost 18 now.
Okay.
Your Honor asked two different questions there, and both are appropriate questions. I'll kind of go in reverse. Under Pennsylvania sentencing guidelines, Mr. Green is facing a 30-year mandatory minimum sentence if he is convicted. So this cannot be rectified at sentencing if he is convicted in an adult court.
With all due respect, I can't imagine any intermediate appellate court not reversing this for an abuse of discretion standard. The question is, are we presupposing the ultimate outcome here? Or how are we, within our jurisdiction, or what are you asking us to do?
Understood, Justice. And I actually respectfully disagree that necessarily this would be reversed on an abuse of discretion standard.
Then take it all the way up here.
Well, understood. And the reason why would be, if we accept the Superior Court's opinion, this court rules the same way the Superior Court did, that order is a nullity. There is nothing technically for Mr. Green, the appellant, to appeal from.
What order is a nullity?
The order of decertification that the trial court issued 30 days late.
Right, but what about, has the order ever been filed on the deemed denial?
No.
Well, that's the order. That's the one that you want, because when that one is issued, you can seek appeal by permission. And I would venture to guess that the president judge of the court, who issued the favorable decision to your client, albeit extremely late, and as everybody knew in the case, was going to be extremely late. I would imagine that she would be very willing, potentially, to certify it as immediately appealable to the Superior Court and have that resolved.
Well, and I don't necessarily disagree with that procedurally. Unfortunately, the position I'm in, I'm guessing and assuming that those things would occur. Because we are not in that position yet, I cannot count on those things to occur. While I presume...
Well, sure you can. You go to the clerk and you file a precipice to enter the order required by the rule. And then as soon as the order is filed, you ask the trial judge to certify it as immediately appealable and on your way.
Understood, Justice Robson, but I can't...
Why isn't that, and counsel, why isn't that the appropriate thing to do here? Because the alternative, it seems to me, is you asking us to rewrite the statute, to manufacture some judicial good cause exception or something like that, which seems beyond our authority. So whether it's what Justice Brobson was just proposing or what Justice Dougherty was proposing or a nunc-pro-tunc remedy, I'm not sure if maybe we're in PCRA land or where we are, but regardless, aren't all of those alternatives more legally sound than I think what you're asking us to do is to create some sort of inchoate judicial exception to a clearly written statute. And suppose you got a majority of the court to agree this is just so unfair, it's just so wrong, et cetera, we've got to do something for your client. What's the principled stopping point to that? What's the rule of law we're articulating?
It is not just my client, Justice Wecht, and combining the questions Justice Brobson, yourself, and that Justice Daugherty had asked, first of all, it would be presumptuous to assume that all those rights are available. While I believe there would be a strong ability to raise those, as your honors have stated, either through after the denial and asking for interlocutory appeal, or after sentencing, or through a PCRA, because I'm not in that position yet, I cannot presume that all those things would be available to me. The court has essentially has an escape hatch here in that the order was not entered in an appropriate fashion, and it could be reviewed as the court just did not enter an order while the statute requires it. The escape hatch is, if you don't, there is no penalty.
Counsel, can I just follow up on that? Because I agree entirely with Justice Brobson. The rule requires the clerk of court to enter an order on the 20th day. The reason that's there is to give you the ability to file that petition for review. That didn't happen here. Your argument is there was a breakdown in the operation of the courts. And if you're standing here now saying that that deemed denial order was not entered, then, that's your remedy. I think your argument before us is it should have been entered. I would have, had an opportunity to appeal then. That right was denied me. Here's my problem with what you're asking us to do here. I view this statute as a jurisdictional determination by the legislature. That's the legislature's prerogative to set the jurisdiction of the court. As I read this statute, the court loses jurisdiction to make that decision on that 20th day. And that's done. We don't have the authority to mess with jurisdictional timelines that the legislature sets. I think what we have here is a breakdown in the operation of the courts. I understand your concern, and I understand the heinous punishment that's in the future potentially for your client, but at the end of the day, we have a jurisdictional limitation set by the legislature on trial courts, and I'm just not aware of anything that would allow us to amend or alter or otherwise look at it. So tell me that I'm wrong about this being a jurisdictional issue.
I do agree it is essentially a jurisdictional issue.
Well,
However,
it either is or it isn't.
yes, it is.
Okay.
And I would ask the court to look at, in the later parts of our brief, the other statutes, the sister statutes to 6322 being 6355, which is to transfer from a juvenile court over to adult court. There are none of these strict jurisdictional statutory rules.
Because the legislature didn't set them.
I understand that.
Maybe we would have written it differently, but, you know, that's the world in which we live under the Pennsylvania Constitution. That jurisdictional determination is for the legislature to make.
I understand what you're saying, Justice Donahue, and my point on that being with these two separate statutes that are sister statutes applied similarly in the same ways using the same factors, that's where we have argued the ambiguity lies in that one permits really unlimited time for a court to make a determination.
Counsel, this is as a direct file, and you then filed a decertification, correct?
That is correct.
Therefore, the impetus was on the defense to seek a decision of the court. Did you at all file a motion to compel, or what did you file to encourage the court to make a decision within a statutory period of 20 days?
Justice Doherty, I would argue that it would not be appropriate for me to file that on the basis of I think I would be in danger of committing an ethical violation or malpractice if I asked the court to file that decision knowing that the court has 20 days to make that decision, otherwise it's denied. So I'm either asking for her to essentially allow it to be denied or face having the court say a denial. I don't know that I have anything within the law that could compel an
I'm
answer.
not sure.
Don't you have the opportunity, or do you not have the opportunity, assuming this is affirmed, and so therefore there's a quashal, right? Is it not still within the bounds of the clerk of court to file that order?
Oh, it would
Right?
be. It would be. Yes.
And then you've got your appeal.
Right.
So what are we missing here?
I don't have it at this point in time, and I cannot. I'm sorry. No. Yes, that is essentially correct, Justice Mundy. Yes.
So yeah, because you're here, you put on your best suit, and we're standing here, and this is great. But I think the law, you want equity,
Correct.
and equity follows the law. The law here seems to provide you a remedy, which is the entry of an order on the denial and a permission to appeal. And I mean, of all the permissions to appeal, it seems like your stars are aligned, because I can't imagine that the president judge in this case is not going to agree that it should be immediately appealed, and on top of that, issue a mighty fine 1925 opinion as to why she thinks it should be decertified, and the Superior Court will review it.
And I don't disagree with that, except for the extent that I cannot guarantee that type of outcome. A court may say no.
Why do
Who
you
can
keep saying
guarantee
that?
anything in
Oh,
the
understood.
law? Who can guarantee anything in litigation? I mean, if the trial judge doesn't own the breakdown, then that's why you have appellate courts.
And Mr. Kiss, this may all be true, and I suspect it is, but you're here today. Do you have any persuasive reason that we should address this today rather than wait for those future events to happen? I mean, you're arguing a breakdown in the operation of the courts. Is there anything that you have to say that would make this more appropriate for us to address now?
Well, I think, Chief Justice Todd, that because it doesn't just affect my client, because this could affect multiple juveniles across the Commonwealth, and because, again, we are talking about juveniles. If this matter goes back, and then I do get the opportunity to file that, my client is going to very quickly, going through the appellate process, if it's brought the whole way back up, potentially even reach 21, where he would no longer be amenable within that system. And at that point in time, there would either have been no release, or he would then not be able to be taken through the juvenile system as appropriate. I understand that the federal government, in passing certain legislation, has asked our courts and all courts to remove children from state prisons, but Mr. Green has been in state prison, except for a short window, a couple months, for nearly the entirety of this situation. So that is really one of the reasons why in equity that I am standing here is my clock is ticking faster and faster and faster.
How old is your client?
He should be turning 18 here,
Okay, so you have 3 years.
roughly 3 years,
And
yes.
how long has he been in jail?
Since February when he turned 15, so 2 years ago.
Okay.
I'm sorry, almost 3 years ago.
Counsel, I just have to take exception to one thing that you said. This is not going to affect many juveniles across the Commonwealth unless we assume that there is a breakdown in the court system in every case, which apparently is not the case. I mean, you have to figure out a way to file an appeal or extend an appeal that encompasses this notion of a breakdown in the court system, because you know, it's clear where the trial court judge was on this. You know, the petition for specialized review is going to be sort of a slam dunk for you, but I mean, there is a mechanism available in this situation, and so this is really not likely to come up anywhere else in the Commonwealth unless every clerk of court doesn't enter that order that's required.
But you're looking at it from the perspective of your client and where he is right now. And I'm sorry to interrupt the answer. Please answer Justice Donahue's question.
But going off of that, and Justice Donahue, if the court reviews, I believe it's either the Bentley or the Khalil case, the footnote in that by, I don't remember which justice it was, stated that it seems to be the practice and not the exception that clerks of courts routinely do not enter these orders. Now, and that's
why we have lawyers.
Yes.
And that's why you have this thing called a precipice, because there are times where, I agree with you, it happened to me in private practice where an order is supposed to be entered as a matter of fact, as a matter of course, and it doesn't get entered. That's when you file your precipice and say, enter the judgment, enter the order, enter this so I can take my appeal. It's a fairly routine thing.
Yes, I appreciate that. And again, but that's relating back to part of the point of why I stand here where we do is that one, it specifically affects my client given his ticking time bomb of a clock, but also because, as Your Honors pointed out, it does tend to occur. Now, again, I may have this opportunity to file this, but I still stand in the position of slightly presumptuous that I will be successful on it, but I understand where the court's position is relative to that, certainly.
All right, thank you.
Thank you, Judge.
Let's hear from the appellee.
Morning, Justices. May it please this honorable court. My name is Peter Weeks. My co-counsel is First Assistant District Attorney Nicole Smith. We represent the Commonwealth of Pennsylvania on behalf of the Blair County District Attorney's Office. As the court is well aware, you're being asked to decide whether an exception to the 20-day deadline should be granted. Appellee submits that the law and the rule are both clear and justified. Simply put, the law and the rule are clear. There is no wiggle room here. 42 PACS 6322 and the rule promulgated at Rule of Criminal Procedure 597C through D are both clear and unambiguous. The statute and the rule clearly tell the court, the lower court, what to do, when to do it, and what happens when they don't do it. They do not cause an absurd or unintended result, nor is the intent of the legislature or the Rules Committee unclear. Appellant is not asking you to correct an ambiguous statute. He is asking you to create ambiguity because of the actions of one lower court. I would also argue that in our research for this case, we reached out to district attorneys' offices throughout the Commonwealth to see if this occurred. We could find no other examples of a court missing the deadline that intended to decertify a juvenile. Appellant argued that the result in this case was unintended by the legislature, which is again belied by the statute and the rule. Appellant's brief suggests that the exceptions be created in the application of the law and the rule. I submit they are written rigidly. There is no other way to apply this law and this rule. This court is well aware that there are black and white, hard and fast rules and time limits that exist in our court system, specifically in juvenile court, specifically when juveniles are detained. Rule 240 of the Rules of Juvenile Court Procedure require informal detention hearing must be held within 72 hours if the juvenile is secured in secure detention. Rule 242, a petition must be filed within 24 hours after the informal detention hearing if the juvenile is detained. Rule 404, the adjudication hearing must be held within 10 days of the filing of the petition. It's known as the adjudicate or release rule. There is one exception, or two exceptions, where additional evidence is not available, and only one single 10-day extension is granted to the Commonwealth, and only upon proof of clear and convincing evidence.
Could I ask you a question? You don't disagree that, assuming we affirm that the deemed decert order gets filed and then they can take their appeal. In other words, you don't maintain that they can't get review in some other proceeding of the decision, right?
I would absolutely agree that review would be available. It would either have to be granted by permission, which could happen in this case certainly, or an appeal as of right if there was a conviction in adult court. I do agree with that.
That is one other point of unfairness, right? On a decertification decision, you get an appeal as of right. On a denial, it's an appeal by permission because of double jeopardy.
Yes, and that is one of the interesting aspects of this case. The actions of the lower court in this case, as stated by the lower court in their opinion, were not because the lower court was not aware of the deadline. They are not because the lower court forgot or got too busy. The lower court emphatically stated in its opinion that they had in fact made up their mind within the 20-day time period, but they chose, as the lower court set forth in its opinion, as was their right to do, which the Commonwealth strenuously disagrees with, to withhold that from the parties, to withhold that from the public, to withhold publication and announcement of that rule and decision. And it is also belied by the lower court's actions in Commonwealth versus Owen Sutherland, the joint co-defendant of Appellant in this case, whose decertification proceeded first. In that case, on page 11 of the lower court's opinion, the lower court said, there's things that I consider that I don't want anyone to know, and I'm sealing them. Again, the Commonwealth did not agree that was legally appropriate, but there was precedent for that judge in this case to say there are things that I don't want people to know about yet, and I am not releasing them to the parties or the public. In this case, the second case of the three who proceeded to decertification, the lower court told the parties in open court, I will render my decision in 20 days. So in some defense to appellant and appellee were certainly expecting the lower court to do that.
But that's little solace to a juvenile who then does not get back to juvenile court. I mean, it is in some sense a breakdown of the operation of the court. That may or may not be an exception, and I guess we're going to have to determine if there can possibly be any exception when we have a clear statutory directive, but that's of little solace to this defendant.
Well, I would argue that the breakdowns discussed both in Breakovich and Khalil decided by the Superior Court were breakdowns in notice. And I would concede that in this case there is a breakdown in notice, but the remedies in Breakovich and Khalil do not extend the lower court's time period for deciding a post-sentence motion. They simply preserve the aggrieved party's right to appeal. And Appellee certainly concedes that there should be no disruption of appellant's ability to appeal at some point. I would point out, though, that when the judge issued her opinion relative to decert on March 9, 2021, she indicates again that the decision was made February 2nd, 2021, which immediately suggested to the Commonwealth that the court was suggesting that we were outside of our 30-day time period. We filed our notice of appeal that day. The response of the lower court was to schedule the matter for an adjudicatory hearing. We questioned that. We got nowhere. We had to file for an emergency stay in the Superior Court, which was granted, and then the lower court released an order indicating, of course, it stayed. What is everybody thinking? And that is the Commonwealth's concern with the behavior in this court, because there was a second issue raised before the Superior Court, which I concede was not is not in front of the justices today. But that question is far more concerning to the Commonwealth in this particular case.
Mr. Weeks, I think you mentioned breakdown, and I just want to say, I think if you're referring to the breakdown being the clerk did not file the order that the rule requires the clerk to file, I agree that there's a breakdown. I'm not sure there was a breakdown with the trial court judge. It seems to me the trial court judge acted very intentionally here. Breakdowns are usually sort of negligent, recklessness, or some just ignorance. It seems to me the trial court judge here knew exactly what she was doing.
I would agree with that. I struggle with what to call that. Well, no, I would argue, Justice White, that there was no mistake. And your footnote in Peck, I think, sums up the Commonwealth's issue with the lower court in this, when the response to go do justice was, that is not my job. My job is to follow the rules. And when you follow the rules, then you can apply justice equally. When you don't follow the rules, then justice cannot be applied equally. And so it is difficult for me to concede that there was a mistake on the part of the lower court. Certainly by the clerk of courts, yes. But the lower court maintains in its opinion that there was no mistake, that everything they did was intentional, and they intentionally withheld their ruling from both sides.
But there's a fail-safe in the rule, which is the mandate that on the 20th day, the deemed denial order is entered. And we're all in agreement that that was a breakdown here. That did not occur.
Yes, that order was never entered.
Okay, so let me just follow up with you. You precisely summarize the status, and let's assume that he now precipices for the entry of that order. Why can he not attempt to appeal from that now, as opposed to waiting until post all of the proceedings?
And I apologize. I believe I conceded that with permission, he certainly could.
Okay, because you said at some point in time, we'll have the right to appeal at some point in time. And I'm just focusing on that particular mechanism of getting the deemed denial order and then proceed from there.
Yes, I would concede that he would have appeal by permission immediately and appeal by right if there's a conviction in adult court. I would also like to go on and submit to this court that there is justification, clear justification, for this rule and for this law. Again, it is just appellant in this case, that at least the Commonwealth is aware of. We could find no other instances of this happening throughout the Commonwealth, and as the court said, there should be a presumption that counties follow the law. At present, this rule forces lower courts to prioritize juvenile decertification matters above anything else. And that is paramount, and I submit that that is completely appropriate. It is appropriate because unlike a certification hearing where a juvenile is in juvenile court and the Commonwealth is arguing they should be removed, this is a juvenile that the law recognizes is alleged to have committed an act that falls outside the scope of a delinquent act. The Commonwealth direct filed in accordance with the law, and the defendant through counsel very appropriately filed for decertification so it could be argued in front of a court to determine what was in the best interest of society. Courts have to prioritize that because time is of the essence. Simply put, I would argue that best interest of society focuses primarily on what is the possibility of rehabilitating this juvenile before age 21, because that is the hard, and maybe it shouldn't be, but that's the hard stop right now in Pennsylvania for the jurisdiction of the juvenile court, age 21. If we can't rehabilitate you, you're not on probation, you're not on parole, you don't check in, you're done and out the door. In this case, and again, this is by way of argument going off my recollection, but appellant was 2 months shy of his 16th birthday at the commission of the alleged offenses, which would make appellant, I believe, approximately 18 and a half today, which, again, is creating a serious time constraint on the rehabilitative efforts for appellant. The judge's failure to announce the decision in open court didn't just prejudice the Commonwealth, didn't just arguably restrict our ability to appeal under her positing that she had made her decision February 2nd. It left appellant in an SCI when the lower court claimed that they had made up their mind. The lower court indicated that was to the benefit of the third and final decertification hearing, which is Commonwealth versus Logan Persing. Appellee can find no authority in the law whatsoever to prejudice the parties in one matter, especially a juvenile in one matter, to the potential benefit for another case. And in that case, Mr. Persing's decertification hearing was denied. So at the end of the day,
I don't think anyone's disagreeing with you about the creation of an exception. I mean, and I don't know, it just occurs to me that when you called all of the district attorneys in the Commonwealth and nobody ever saw this happen before, It's probably because the deemed denial order was entered on the 20th day.
Well, the comment we received, and again, this is just based on our research, I can't independently, verify the accuracy, was when the judge intends to decertify, they always make their deadline. Sometimes the judge, in lieu of writing an opinion when they don't intend to decertify, will let that lapse, but never when they wanted to decertify, because they recognize the rule mandates the decision and they have a duty to make that decision within 20
But
days.
unfortunately, the decision of the court is not at issue here. The issue here, and as a trial lawyer, we've all experienced trial judges not responding and permitting our motions to be denied by operation of law. That's what transpired here. The concern that I have is the fact that that order was not filed to give immediate appellate issues to the defendant.
And my respectful argument to that, Justice Daugherty, would be, in this case, it wasn't a lapse on the trial judge's part. It wasn't a failure. It was intentionally withholding that announcement, that decision. I know we're not here for.
But that's not the issue before us right now. That
It
must
is-
have been your second issue.
It is not, but in a way it is, because if there is an exception to this rule, I would respectfully submit, it would encourage this type of behavior throughout the Commonwealth, and this type of behavior must be discouraged. It would,
Maybe just in the pursuit of justice, maybe you and the opposing counsel should walk out and file a joint precipice to have that order issued on the docket right away.
I certainly would agree that when jurisdiction is returned, we could do that. I'm not, and I apologize if I'm incorrect, but I don't believe that would be maintaining the status quo, which would be permitted. I think we would have to wait until jurisdiction would return, but we would certainly consent or join in appellant's motion. Unfortunately, this case, I think from Bo's perspective, needs to go back to square one to start up again, and that is not to the protection of society, and certainly not to the rehabilitative needs of the appellant. So it is.
That's a commitment on behalf of the district attorney's office, if we rule that way, that you would agree to a precipice as soon as jurisdiction is returned?
Absolutely, Justice Todd. Recognizing that what appellant argued was true about the mandatory sentences right now for juveniles charged with second-degree murder, I would indicate that in this case, the other three co-defendants' cases are resolved, and the two individuals charged solely with second-degree murder were resolved for far less than the mandatory minimums. So I understand that is a real risk for appellant, and I'm not trying to take that away or argue that that's not out there, but I would also like to interject that the Commonwealth recognizes that and tried to take a more middle ground approach in disposing of their cases.
And I think that we're not there yet.
Agreed.
Thank you.
Thank you.
Thank you both. We'll return at 12:30 to hear the remaining cases on the list, Shrom versus Pennsylvania Underground Storage Tank and Myers versus Commonwealth. So those counsel are free to take a break as well, and we'll resume at 12:30.
session. Please be seated.
Call the case, Mr. Minner.
Dr. Timothy and Deborah Shrom versus Pennsylvania Underground Storage Tank Indemnification Board. Representing the board, Mr. Robert Gaulis Jr. Representing the Shroms, Mr. Jason Confair.
In this case, the owners of underground storage tanks discovered a release from the tanks necessitating remediation. At that time, the registration for the tanks under the Storage Tank and Spill Prevention Act had expired due to non-payment of fees. However, after the discovery, the owners paid the outstanding fees. They then submitted an indemnity claim for the cost of the cleanup to the Underground Storage Tank Indemnification Board, which denied the claim, noting that at the time of the release, the time the release was discovered, the registration for the tanks had expired. The question before us is whether the board properly denied the indemnity claim, even though it had not promulgated a regulation tying indemnification to timely tank registration. If that's about right, please proceed.
May it please the court. My name is Robert N. Gaulis Jr., and I represent the Pennsylvania Underground Storage Tank Indemnification Board. Madam Chief Justice, one point I want to clarify is that the claim was submitted upon discovery of the release, and the tank registration did not take place until some 3.5 months after the claim was submitted to the Underground Storage Tank Indemnification Fund.
Thank you.
Your Honors, this case presents the court with the opportunity to confirm that the timely registration of underground tanks is an essential requirement of the comprehensive regulatory scheme enacted by the General Assembly in the Storage Tank and Spill Prevention Act, and is not something that can be overlooked or ignored until a release is discovered. The indemnification fund eligibility requirements don't exist in a vacuum. Instead, they must be considered in the broader context of the entire Tank Act. In this case, the General Assembly included tank registration in accordance with the requirements of Section 503 of the Act, and would not have done so if that requirement were simply something which could have been ignored until a claim arose. In reversing the board, the court below treated the tank registration requirement as a mere formality, and in doing so, construed the Tank Act in a way which failed to give effect to all of its provisions and to effectuate the intent of the General Assembly. The Tank Act sets forth a comprehensive regulatory scheme for the purpose of, among other things, preventing and detecting underground storage tank releases.
Counsel, pardon me, how are we to make sense of the difference between 706.2 and 706.3 in particular the presence in 2 of the currency requirement and the absence of that requirement in 3? Don't we have to give meaning to that legislative distinction?
Well, Your Honor, I do not believe that there is a distinction respectfully submitted. Section 706.2 requires that the gallon and capacity fees provided for under Section 705 of the Act must be current, but does not say that they must be current at the time the release is discovered. In the same way, Section 706 subsection 3 provides that the tanks have been registered in accordance with the requirements of Section 503 of the Act, and again does not say at the time the release is discovered. However, you have to look at the regulatory scheme set forth in the Act. The regulatory scheme requires DEP to establish an underground storage tank program, which provides for the annual registration of tanks as well as the implementation of procedures for the operation of underground storage tanks.
I think that's clearly the scheme, the legislative scheme, Counsel, but given the absence of an explicit currency requirement, doesn't that ambiguity have to be construed against the fund rather than against the claimant in the absence of legislative action or notice and comment procedures for regulations?
Well, Your Honor, we submit that in construing the act itself, you look at the requirements for tank registration, and the Tank Act requires that tanks be registered by completing and submitting a Form 2 DEP and paying the registration fee required by DEP. And in that regard, 25 PA Code, sections 245.41 and 245.42 require that the tanks must be registered on an annual basis prior to the preceding year's tank registration by paying the fee that's prescribed by DEP for tank registration.
And what's the consequence?
Well, Your Honor, the consequence is that if you do not register the tanks in accordance with Section 503, under Section 706, subsection 3, you are ineligible for coverage by the Underground Storage Tank Indemnification Fund.
That's what you say the consequences are, but the facts here don't show, at least in my review, that that's how DEP treated it. Factually, these tanks had been registered, and DEP and presumably the Underground Storage Tank Fund were aware of the existence, which is the purpose of registering them. The fee was not paid for a particular year, 2017, I think, correct?
That's correct, Your Honor.
Okay. But when that fee wasn't paid, DEP pursued collection for the 2017 fee, went after the collection. Now, if, as you say, the failure to register in 2017 meant that the tank was not covered in 2017, why would you pursue a fee for 2017 and try and collect it, and indeed did collect it? What does someone in that situation get for paying on the collection?
Well, Your Honor, the fee was sought by invoicing the last registered tank owner and operator, Quarryville Sitco Subway LLC. The registration fee was not paid because the Shroms, once they assumed control of the tanks, failed to abide by the requirements of Section 245.41, which required that amended registration information be provided to DEP.
You're making it much more complicated than the question I asked you. There was a registration fee due for the tank that wasn't unpaid, right? That was unpaid.
It was unpaid.
Okay. And rather than simply noting it was unpaid and therefore coverage would not be provided for the tank during that year, DEP pursued collection on the unpaid fee, correct?
That is correct, Your Honor.
Okay, and DEP received collection for the unpaid fee, correct?
It did 10 and 1/2 months after the tank registration
But they accepted
expired.
it. There's a little doctrine called accordance satisfaction. They accepted it, correct?
They did.
They did not turn it away and say, sorry, your registration lapsed, there's going to be no coverage. So my question is, when they paid that fee, what did they get for it?
Well, Your Honor, the fund and the board have no discretion in applying the eligibility provisions of Section 706 and the regulations promulgated.
You're not answering my question. You pursued the fee for 2017. They paid the fee for 2017, but now you're refusing to give them coverage, even though they paid the fee for coverage.
They paid the fee for registration, Your Honor.
Right.
The eligibility provision is somewhat different in that it mandates that the tanks have to be registered in accordance with Section 503. And in this case, they were not because they...
Why then pursue the fee? That's what I don't understand. If they weren't registered for that year, and you say the remedy is they're just not registered if you don't pay the fee and they don't get any coverage. They paid the fee. You could have not pursued the payment, not pursued the collection. If your true position was the result is they have no coverage. But it seems to me you acted inconsistently, that the Commonwealth acted inconsistently here. Tell me why I'm wrong.
Well, Your Honor, the Commonwealth Court recognized that if the tank fees had not been paid as of the time the release was discovered, there would be no coverage. There is no reason to treat the failure to register the tanks in a way different than you treat the tank fees.
On that answer, because I'm not sure I follow that. In the statute, the legislature has specified that the tank fee, pardon me, that the tank fee is set on an actuarial basis. So not only can we infer, but we can actually read explicitly that the legislature has said those tank fees are the actuarial hook, whereas the registration fee is something different. That's going to DEP. So I guess I don't see how your response satisfies Justice Brobson's question, because the legislature chose to break these two fees out, treat them separately, use different language with respect to them. So let me stop there and see if you want to respond to that.
Well, what the Commonwealth Court did in reversing the board was it ignored that while the tank fees go to the Underground Storage Tank Indemnification Fund and the registration fees go to DEP, the tank fund uses the registration information it receives from DEP in order to invoice tank owners for the Section 705 tank capacity and gallon fees. And they rely upon current and accurate information in doing that. And they also rely on current and accurate tank registration information in performing the actuarial analyses they need in order to set the appropriate tank fees for a given year.
And did the, just brief follow-up on that, did the provision by the owners, or perhaps it was the previous land possessor, that the tanks were inactive, that it was their status was frozen, right? There was no current tank fee being paid because of that inactive status? Did that provide the actuarial information needed by the board?
Well, if you look at this specific instance, Your Honor, no tank fees were owed for that tank during the period it was not in active use. However, again, you have to look at the broader regulatory scheme. And the fewer tanks that are registered, the fewer tanks can be billed for Section 705 fees, including the capacity fees, by the board, by the fund. And therefore, the less money that's being taken into the fund and the less money that it has in order to pay for remediation efforts on behalf of eligible tank owners and operators.
I think your argument would be more persuasive, though, if you were dealing with a tank that was never online, that had never been registered, that had never paid the capacity fees. This is different. This is a tank that was online, that everybody knew was registered, and it was a collection matter. It was a collection matter with DEP, and they pursued collection, and they got paid.
Yeah, but, Your Honor, the General Assembly specifically required the registration requirements for underground storage tanks. And among those requirements are that the tank owner provide specific information to DEP concerning the tank itself, the tank owner, the tank operator, and contact information relating to the tank. And in this case, the Shroms claim that they did not receive any notices or invoices for the tanks. And the reason for that is because DEP sent notices and invoices to the last registered tank owner and operator. And none of those invoices or notices were returned. If the Shroms had amended the tank registration, as we submit they were required to do by the Act and the regulations promulgated thereunder, they would have received those notices, but they never did. And not only does Section 245 require tank owners to provide registration information regarding the specifics of the tank owner and operator and the tank and its contact information, but the same section requires that if there is a change in the situation, such as a relocation of an underground storage tank or a change in the owner or the operator, then amended registration information must be submitted to DEP within 30 days.
Well,
And there's a-
let me just, I'll stop, because I'm seem to be monopolizing this a little bit, but let me just put aside the owner-operator question for a different time. If I am the owner-operator of a tank, and I fail to pay my registration when it's billed, and when it's due, technically, and it goes to collections, and after a couple of months, or maybe even a year of collections effort, I finally pay it. Your point is, even though I paid the registration fee for the period in which the release occurred, because I paid it late, DEP gets that money for nothing, and I get no coverage.
Well, that's correct, Your Honor, because the coverage is not retroactive, as the courts have held.
So what did I get for paying that late fee?
Well, you certainly don't get coverage under the fund because it's a mandatory.
I understand. What do I get?
Your tank is now re-registered, but that doesn't make you eligible for coverage under the fund.
So it can be retroactively re-registered for the period of the unpaid fee, but that doesn't get me coverage.
It's required to be registered on an annual basis. If there was a lapse in the registration, but the tank was registered before a release was discovered, then there would be coverage. But you can't go back after a claim has arisen and then make yourself eligible for coverage for paying a registration fee, which should have been paid 10 and a half months before.
Let me just see if I can follow up, because maybe I'm misunderstanding, but if you're correct, that as a matter of law, the non-payment of the registration fee is disqualifying, then the successive and persistent attempts to collect thereafter undo your position. I mean, they're highly suggestive of an effort to reach an accord and satisfaction, such that in effect it's like saying, if you don't pay me, you're not going to get coverage. Pay attention. If you don't pay me, you're not going to get coverage, and you're like chasing them down the hallway, as opposed to saying, oh, you're running down the hallway, okay, no coverage. It's a bad metaphor. But do you understand the way I'm casting it?
I believe I do, Your Honor, but the difference is that in this case, they sent the notices and the invoices, and there was no payment of the registration fee until after the claim arose. And the reason there was no payment of the registration fee or re-registration of the tanks was because the Shroms never filed the amended tank registration information with DEP, which they were required to do.
If they were owners and operators, they were required to do it.
Well, Your Honor, I submit that once they assumed control of the tanks and altered the tanks by removing them from the ground, they became operators within the definition of Section 103 of the Act, which defines an operator as someone who controls or alters a tank. So once they assumed control, hired the contractor, and had the tanks removed from the ground, they were operators, and they were required to comply with the registration requirements of the Act.
So, if you pay your fee late, you are now registered. That's what you get for paying your fee.
Your tanks are registered, correct?
You're paying to register, and it is registered. If they had paid this fee one day before the problem was discovered, they would have had coverage.
Correct, Your Honor.
So, if that's how it works, why would anybody pay the registration fee until after you have a leak?
I'm sorry, Your Honor?
Why would anybody pay the registration fee until you have a leak? I mean, if you can, retroactively get the coverage, why would you bother paying it?
Well, that's exactly the problem, Your Honor. If there are no consequences to failing to register the tank as required by the Act and the regulations, and if there are no consequences to failing to pay the registration fee, you're going to have more unregistered tanks, and that is going to hinder the regulatory scheme
Well, that's
by
a different,
which
that's a different issue. But I mean, the broader issue is if you could wait until you have a leak in order to bring your registration up to date, why would anybody register until there was a leak?
Well, I think the distinction is the discovery of a leak. I
Correct.
understood your question
It is, and
to be
I meant the
premised.
discovery of the leak.
Okay.
Right. Why would you bother paying a registration fee to bring up to date a lapsed registration? Why would you bother doing that if you could just wait and see whether or not you're going to discover a leak?
Well, for one thing, you're required to do that by the Tank Act and
I'm
the
agreeing with
regulations.
you. I'm agreeing with you. I mean, there'd be.
She's trying to help you.
I'm trying to
Well,
help you.
I
I'm
understand,
trying to
and
help you. I mean, you don't want to argue with me on this one because
Well-
I think the quid pro quo for paying the registration fee is that now you are registered and now you are in compliance in the act. That's what you get for paying the registration fee.
That is
See,
correct. and
but
I-
here's the problem though with the hypothetical and the concern in the insurance industry. Which you're sort of an insurance policy. I know you don't. I know the fund doesn't like to say that, but you sort of operate as an insurance company. You indemnify for risks. In the insurance industry, if someone files a claim and their policy has lapsed for unpaid premium, and then they try to, or they have a claim and they didn't file it, but they try then to pay premium retroactive and then file the claim, the insurance company wouldn't accept it. They wouldn't take the payment because they know if they do, then they have to provide coverage because the premium is retroactive for the period of coverage. Here, you accept, I say you, the Commonwealth. The Commonwealth accepted a past due registration fee for the period of time within which the loss was reported. Arguably, if you apply insurance principles, you're on the hook.
Well, Your Honor, you are correct that the Commonwealth does not agree with your comparing the statutory underground storage tank indemnification fund with insurance because it is not insurance. It's a statutory fund. And it's well established that in order to be eligible for payment from a statutory fund, you must meet all of the eligibility requirements set forth in the Act and the regulations promulgated there.
It's a risk spreading regime set up in the public sector, set up by the government.
It is, Your Honor, and in that regard, it is similar to insurance, but again, it is not insurance. And again, here, you can't look at the eligibility requirements in a vacuum. The use of coverage is all part and parcel of the Storage Tank and Spill Prevention Act. And again, among the provisions for the Act or the purposes of the Act are to prevent and to detect underground storage releases. And that's why the tank registration requirement is in effect. The DEP and the fund and the board want to encourage the registration of underground storage tanks. The General Assembly wanted to encourage the registration of underground storage tanks. That's why they included that provision in not only Section 503, but also in the eligibility provisions of Section 706.
Is this like a deductible? Does this function like a deductible? What do you think of that?
The registration fee, it does not. Under the fund coverage, there is a $5,000 per tank deductible, which must be paid by the eligible claimant before the fund begins to reimburse the claimant for the costs of remediation.
Counsel, how does the fund, I see how the fund defines owner, but what verification is needed to make one an owner? Is it just a registration or is there more? Because here's the scenario I have. In 2014, Rhodes sold this underground storage tank to Quarryville. And in 2016, Quarryville filed the out-of-service registration with you guys. And it was out of service, and then Shrom files a registration after the reported release, and he excavates it and remediates it. But if I read your definitions, under owner, it's in the case of a storage tank in use on the effective date or brought into use. And if you read that in paramateria with registration and eligibility of claimants, this is not in use. And when I read your act, it seems that your preamble is to provide the health and safety of its citizens. So if you have a good Samaritan, AKA the Shroms, who invested $173,000 to remediate for no other purposes that it was on its property, despite the fact that they are not the owner, why would it not be the equitable remedy to use the fund to pay them back for the remediation? Because I see us arguing over ownership. Unless you waive the argument and assume there are, I don't see how the Shroms are the owners pursuant to the facts on this record. It's not in use, and there's no definition. All they did was possibly file a registration claim with no indication, unless you just accept anybody filing registration claim to the ownerships. Is that how you do it? Like hypothetically, if Justice Donahue and I both filed registrations for this underground storage tank, we both decided to remediate, are we both entitled to it? Are we both owners?
If you are the registered owner, yes, you would be entitled to coverage so long as you satisfy the other eligibility requirements. In this case, the Shroms assert that they were neither the owners nor the operators of the tanks. And if that were true, they would not be eligible for coverage from the fund in the first place. But I'm sorry, go ahead, Your Honor.
No, I apologize. I cut you off.
Here, the Shroms were not good Samaritans. This is not a case where they were unaware that there were storage tanks on their property.
Right.
In fact, they stipulated that the property had been used for the operation of gas stations for years prior to Mrs. Shrom inheriting the property from her mother. Right. They also stipulated that when she did inherit the property from her mother, she continued to lease it for the operation of gas stations. And so she was aware that the tanks were there. The Shroms, and not the fund, and not the board, not DEP or the Office of Attorney General, were in privity with the tenant, who was the last registered owner and operator of the tanks. This is also not a case where the Shroms could have done nothing to protect themselves. Once they made the decision to remove those tanks from the ground, they should have verified that the tank registration was current. They could have had their consultant verify with DEP that the tank registration was current.
Understood. You answered my question there.
Thank you, Your Honor.
Well, any other questions? Hey, do you want to sum up?
Yes, Your Honor, in this case, the board's denial of the Shroms' claim was not only appropriate, but it was in fact mandated by the eligibility requirements of the Storage Tank Act and the regulations promulgated thereunder, because by their own admission, the tanks were not registered at the time the release was discovered, and was not registered until 3.5 months after they made their claim, which arose when the releases were discovered, and 10.5 months after the registration had expired. Therefore, the Commonwealth Court erred in reversing the board's decision, and this honorable court should reinstate the board's order.
Thank you. We'll
Thank
hear
you.
from the appellee.
Madam Chief Justice, Honorable Justices of the Pennsylvania Supreme Court, good afternoon. My name is Jason Confair, and I'm here appearing today on behalf of the appellees, Dr. Timothy and Deborah Shrom.
Do you want to pull the microphone up a little closer?
Sorry about that.
That's all right.
Thank you. I wanted to start off really with this concept of retroactive coverage that you asked about. I think it's really critical to understand that there's two species of fees here. The Section 705 fees that actually go into the fund and provide liquidity to the fund, and then the tank registration fees that go somewhere else. So I think the appropriate analogy here would be, I'm a homeowner, I buy an insurance policy, my premiums are paid, my house burns to the ground. I file an insurance claim. Insurer comes back to me and they said, well, just so you know, your premiums are paid. but you didn't pay a broker a $250 fee. Okay, didn't realize that. I go pay the broker the fee. 4 weeks later, after I pay the broker the fee, the insurer comes back and says, well, sorry, your premiums were all paid before the occurrence. That's true. But you didn't pay that broker fee until after the occurrence. And you did pay it, so the broker is whole. But if other people don't pay the fee, the broker might not send out invoices. And that could potentially harm our ability to recover premiums in some other situation.
But isn't that a somewhat unfair comparison to compare a broker to the Commonwealth in this situation? I don't really follow your comparison.
Well, I think, again, it's more of an insurance indemnification concept as opposed to a private insured government comparison is what I was trying to get at. But I think the salient point I'm trying to make here is that there was no harm to the fund. The fund received all its fees. The Commonwealth received all its fees. The fund received all its money before the release occurred.
But isn't the harm in allowing that conduct the fact that nobody else would ever pay the fee until they realized they had a release from the tank, and then they would rush to the post office to mail in their fee, so then the next day they could mail in their claim for money under the fund?
No, I mean, I understand the concern, but I think it goes deeper than that. And I think it speaks to Section 705 fees that go into the fund. And as I noted in my brief, it's really a binary situation, right? If those Section 705 fees aren't paid when the occurrence happens, you're disqualified.
But if you're
So running,
excuse me, but if you're looking at the Section 705, in order to receive a payment from the fund, a claimant shall meet the following eligibility requirements. The current fees required under Section 705 has been paid, and the tank has been registered in accordance with the requirements of Section 503.
Yes.
So how do you get around that?
Actually, relatively easily, with all due respect, Your Honor. So when I say, the current fee required under Section 705, current. Then you turn to Section 05, and what does it talk about? It talks about annual fees, annually evaluating fees, actuarial fees. Then you turn to the provision under 7063. It says the tank has been registered in accordance with the requirements of Section 503. You turn to Section 503, and it talks about registering the tanks one time. It says nothing about annual registration. And in fact, that statute actually provides a defense in situations where the government tries to enforce remediation. It says the defense is, if you've registered once, we can't enforce. Annual wear. That's under Section 7. So that's Section 705. That annual fee discussion is in Section 705. By contrast, in Section 503, they talk about one fee, the initial registration. And in fact, then the statute goes on to say, once you initially register, if we come after you, you can use that as a defense. So there's a very clean distinction on the statutory face of those two statutes. The other point I'd note is that on the face of Section 706, there's a distinction. As the Commonwealth Court found in 706.5, there's this provision, there's a timing mechanism that states that the Section 705 D fees have to be current when the release is discovered. There is no such section for tank registration fees under Section 503.
Counsel, can I follow up on that? Because I thought Section 503A, and of course you're much more familiar with this than I, requires the owner to submit documentation and pay a registration fee each year.
503A?
503 period, I'm sorry, 503. Owner submit documentation and pay a registration fee each year.
It actually says, yeah, every owner of an underground storage tank must submit the form within 3 months of the effective date of this act. And then it goes on to say after 12 months after the effective date of this act, it's unlawful to sell or use an unregistered tank. So it does not talk about annual registration. And again, in 503B, it states, it shall be a defense to an enforcement action under this subsection regarding delivery to an unregistered tank that the tank in question had been registered in a prior year. So right there, it's not as clean as it could be, but you can certainly discern the distinction in the face of the statute, and that distinction is completely consistent with the economic difference in substance of these two fees.
Is there an annual registration fee or not? I mean,
Yes.
there must be, because
Yes.
that's why we're here.
Yes.
Okay.
But they send you an annual registration fee invoiced based on your existing registration. It's,
Yes,
so it's an invoice based on a tank that is already registered.
Yes, sir.
To keep the registration in place, correct?
Precisely.
And at any point in time prior to you filing the claim, did DEP notify your client or the owner that your tank was no longer registered for non-payment of the registration fee?
Your Honor, my client, and this is in the stipulated evidentiary record, received no notice. And what's also in the stipulated evidentiary record, which is most troubling about this, is my client submitted a form 4 months in advance to DEP telling them, we're extracting these tanks. We waited 4 months. Nobody said anything to us.
About the tank not,
Yes,
about this
nothing,
view that the tank
nothing.
is no longer registered?
Right, nothing.
Well, that brings me to the following question. Supposing that we find the statute ambiguous, with the currency requirement and the absence of it, with the registration, et cetera, and we look to the canons of construction, do we prioritize the solvency of the fund, or do we prioritize the incentivization for the Shroms or similarly situated people to engage in remediation, and why?
Your Honor, the question is a good one, and my answer to it is you prioritize people like the Shroms for a few reasons. One is it's a remedial statute, but two, there is no evidence that late payment of tank registration fees, not Section 705 fees, tank registration fees, has any financial impact whatsoever on the solvency of the fund. It is a classic no harm, no foul situation. In this case, all the Section 705 premiums were paid up front in the fund by the time the release was discovered. So it really is not a solvency issue with respect to tank registration fees. And with that being so, I think you absolutely have to incentivize folks like this, where people basically abandon gas stations and pollute their property, to go ahead and promptly invest resources to fix that problem.
And I suppose you would argue that ultimately the public will be on the hook anyways, because if the Shroms die, and I mean, the state's not going to be able to go after their estate to finish the remediation, presumably, right?
Well, as the record stipulates, my clients are retired, they don't have any more money for this. I mean, it's just as simple as that. I mean, the state can come and throw them in EPA jail or whatever, but there's no more money to take. There's no more money for them to invest. So, you know, I don't know what happens, but...
One thing that'll happen is the chemicals will leach out.
Right, as they've been doing for 4 years.
All right, would you like to sum up?
Justices, I think my brief says a lot of my sentiments about this case. You know, there's no regulation, there's no statute. They keep saying, well, the Tank Act requires this, the regulations require it. It's all empty language. There's nothing in the statute that says you're gone if a tank registration fee is late when the release is required. They could pass a regulation like that, they just chose not to. They just chose not to. You know, I'm really here to ask for better future, a better future where people know what is expected of them. They know the requirements. They're not ambushed with things like this. My clients, they did the right thing, in my view. They didn't sit on a problem. They inherited this problem. They gave notice of what they were going to do. The state basically ignored them. And then the state let them proceed. The state let them spend this money. And then 5 months after the fact came back and said, sorry, you didn't pay a $250 tank registration fee. Well, then we go ahead and pay it. There's no harm at all to the government here. They lost out on nothing. They got every penny they were supposed to have. They've invented a technicality now to interfere and interrupt with the effect of a remedial statute.
All right, Mr. Confer, thank you. Thank you both.
Pennsylvania, and BJ's Wholesale, representing the Commonwealth, Mr. Michael Squincy, representing BJ's Wholesale, Mr. Jeffrey Daly, representing Mr. Myers, Mr. John O'Connell.
All right, in this direct appeal, we're asked to consider the circumstances under which a taxpayer is entitled to pay sales tax on only the discounted purchase price of an item purchased with a coupon. Specifically, we must address whether under Section 33.2B2 in Title 61 of the Pennsylvania Code, a vendor must identify on the sales receipt the taxable item to which the coupon applies in order to entitle the taxpayer to pay sales tax on the discounted purchase price. Now, you've caused me to look at all my receipts very carefully since I read this case, so hopefully you're going to make this all very clear to us. Please proceed.
Thank you, Madam Chief Justice, and may it please the Court, my name is Michael Squincy. I'm a Deputy Attorney General with the Pennsylvania Office of Attorney General. I'm here representing Appellant, the Commonwealth of Pennsylvania. I'm also here with Mr. Daly, who's representing BJ's. We are going to divide up our arguments so there'll be no piling on today. I will be addressing two issues. First, I'll address how the Commonwealth Court majority erred in conflating two regulatory elements into one, contrary to core canons of construction. Second, I'll address how the majority erroneously concluded that every coupon is covered by this regulation. Mr. Daly is going to address how receipts should be examined, and that is not in their entirety, but each sale must be considered a separate sale at retail. As you've outlined, Madam Chief Justice, this is an interpretive case, and as with any interpretive case, we have to start with the plain text. And the plain text sets forth two elements that I'd like to discuss today: a separately stated and identified element and a description element. Everyone agrees that the separately stated and identified element relates to the amounts. So naturally, logically, and consistent with core canons of construction, the description element must relate to something else. But that's not what the majority held here. They said that both elements relate to amounts. And to prove my point, I'll just point to a couple lines from the panel's opinion on page 18, where they said amounts representing the items and scanned coupon were separately stated on the receipts, and the receipt described the amount of the coupon. So there, both elements are relating to amounts. Our position, the proper interpretation of this regulation is that the description element has to relate to the nature of the coupon. That's consistent with the very word describe, which is an account of the qualities or characteristics of something. No one goes to Best Buy and says, describe the amount of this TV. And they say, tell me the price, or what is the price? So very simply, our position is that all this receipt had to say here was $1 off Tide laundry detergent, and that would satisfy the regulation. $1 for the amount off Tide laundry detergent as a description. This is not an impossible standard to satisfy, as the taxpayer has argued here. And I just point out that by combining these two elements into one, the Commonwealth Court majority violated at least two core canons of construction, which is that every part of the statute or regulation must be given effect, and that no part should be rendered mere surplus.
So counsel, if I may, If I may, I pulled from the record some of the BJ's receipts, and if I understand you correctly, for example, there was one with a BJ's logo indicating the Tidy cat litter was purchased at $13.49. It then indicates that it was scanned coupon minus $3, which brought the subtotal down to $10.49. PA tax of 6%, which was 81 cents, for a total of $11.30. And mathematically, the tax was on the Tidy Cat without the scanned coupon. But it then, on the same card, indicates that it said, he is a BJ's member, quote unquote, I just saved $6 or $5.02. Total coupon savings, $3. Member savings, $2.02. And that gave them rewards earning $24. Explain to me how what you just said was not identified on this coupon.
Well, I think the price is identified. What we're saying is that it's not describing the nature of the coupon, and this really gets into my second point, Your Honor.
No, it's applied to one item.
Right, but not, I think this is the assumption, this is how the Commonwealth Court majority sidestepped the description element, which is that not every coupon is covered by the regulation. So there are things that are outside the regulation that are not covered, and I think the Commonwealth Court made 3 errors on this issue. One is that this was raised sua sponte by the court. No one ever contested that there are some coupons outside the regulation. And because the Commonwealth Court majority did not have the benefit of our analysis at the time, they made 2 errors. One is that this is a negative implication canon, that there are specifically identified certain coupons that qualify, which means that some do not. And we've used several examples in our brief. One I'll just highlight here is shopping on a particular day. You know, there could be a coupon for shopping on a particular day. That does not relate to the purchase of an item and the presentment of a coupon related to the...
Well, I think I kind of understand your argument, except with respect to receipts for only one item. How can there be any confusion if the only item on the receipt is the Tidy cat litter?
Right. Again, but just as a reminder, the receipt said scanned coup, so we don't know the description.
But we know it was applied to the.
We know that it was applied to the total price. Correct.
And the BJ, the manufacturer, they do the program for the scanning of these coupons. Correct.
BJ's is the wholesale retailer. That they're not manufacturing, as I understand. I think.
No, but the person who programs, for example, if you're now are you sharing with us that BJ has within its authority to do as the regulation said, but they circumvent that so they can charge the taxpayer the full amount. And you're the Attorney General. Maybe you should be looking at the operation of BJ stealing from citizens. I'm really.
I understand that.
But based upon your seriously,
I understand that sentiment, Your Honor.
Let's be clear, that's not happening.
I understand that.
I don't know. I'm asking if that's what's happening because what you just said is that the coupon doesn't define the way the law requires the coupon, and this is a BJ coupon offering its coupons pursuant to 303.33.2B2.
I understand.
So if it's within it. So now and they're charging a tax on the full amount. So it's within BJ. To me, it's almost like fraud.
I understand that sentiment, Your Honor. And
I can't wait for BJ's to come up and try to explain that to us.
I have several.
We're going to tell you that you're wrong, right?
I have several responses to that. One is that, as Judge McCullough pointed out in their dissent, there's no law or regulation that requires certain technology to be used. Now, I can think of more rudimentary ways to satisfy it. Even handwriting it on the coupon might be a way. That's not what happened here. And I keep in mind that in all these kind of tax cases, the Department of Revenue cannot be present for every transaction that occurs in the Commonwealth. And it's just no different than, I think...
Are you saying that the burden is on the consumer to prove what coupons to use?
I think at this stage, it is the taxpayer's burden.
Is the coupon given back after BJ's accepts it? The answer is no.
I don't know the answer to that.
Have you ever used a coupon?
I have.
And have you ever gotten a coupon back after you used it? Because it usually says one-time use only.
I have, Your Honor.
Okay,
and-
so when you gave your coupon, did you get it back?
No, but.
All right, but now you're telling us
But,
the
Your
burden
Honor-
should be on the consumer to get the coupon back from the merchandise. Is that what you're telling us?
No, what I'm saying is, the regulation requires that the documentation be on the receipt. So whether they got it back or not, that's what.
So when it says, BJ, you just saved $3 from the coupon on Tidy Cat, that's not good enough?
It doesn't, I don't believe it says $3 off Tidy Cat.
It says
Tidy
Tidy Cat.
Coop.
It says scan coop, $3. What else did they take it $3 off of? And mathematically commonsensical, if it's $13 minus $3, you bring it down to $10 plus the tax. It makes sense mathematically. So one would not have to go within the four corners of the receipt to understand that the coupon was only given on the Tidy Cat kit lid.
I think the assumption again is that this $3 was specifically for the coupon, this one, that had to do with Tidy Cat. It wasn't for something outside. And just to address some of the other
Part of
points,
the evidence, Commonwealth. You put this in the record. So it is about Tidy Cat. Because if it happens here, it could happen anywhere. And when you take these 18 cents and you times it by class action, a lot of money.
But if I could just follow up on Justice Doherty's question, and maybe I'm confused here and you can enlighten me. It's likely that I'm confused about this, but I see your argument with respect to multi-item receipts, but I don't see your argument with respect to single-item receipts.
I think I don't want to continue to say the same thing, Your Honor, but I would say that we're assuming.
Maybe say it a little louder.
I think we're assuming that this coupon was for Tidy Cat as opposed to where it says scanned coop. And I've pointed to several different ones that it could have been something for shopping on a particular day, which is a coupon that BJ's uses. That's at 144 of the record.
What does it matter if it was applied in this instance to one item?
Well, but because that would be outside the statute talks about taxing the fair value or the total value of tangible personal property. A coupon that gives you $1 for coming into the store has nothing to do with the total value of the tangible personal property. It's for conduct, not for the fair value of the property. That's why it's outside the regulation
But in
and
the
the statute.
final analysis, it has the same result. You get $3 off your Tidy Cat.
You're getting $1 off, but it's not related to the item that you've purchased, and it hasn't been a coupon presented that relates to the purchase of that item.
But it's applied to that purchase.
It's applied to the purchase.
Okay.
Yes.
So can there are coupons that are scanned that fall within the statutory regulation, and there's coupons that may have been scanned that fall outside of the statutory regulation.
That's exactly what I'm saying.
And how do we know which is which?
Right, and the only proof that the regulation permits is the receipt.
Can you give us some other examples of the type of coupons that fall outside of the statutory regulation?
I think we mentioned a few in our brief. One was a tax absorption coupon, which would not fall within the regulation for several reasons. One being that it's actually not a reduction in the purchase price. It's paying for the tax itself. It is covered by the regulation. It's specifically in there.
Can I follow up on that before you move on? Because I'm sort of with you on the the lack of ambiguity in the code, the regulation itself. Let me just ask you to explain how example small I in 61 PA Code 33.2 is any different than the single purchase at BJ's. And that's the one that talks about a buy one, get one free.
Right.
Customer goes to restaurant with a buy one, get one free coupon. Price of one is $1. R rings up 2 on register. R enters a credit in the cash register for the amount of $1, resulting in the adjusted price of $1. All it says you had to do here was enter a credit in the amount of whatever it is. It doesn't say buy one, get one free. It doesn't say manufacturer's discount. It doesn't say anything. In this example, all the restaurant did was enter something that said credit, $1. No problem.
I think
example says.
I might disagree with you there, and I think it says that buy one, get one free coupon was used.
Okay, but it doesn't say that was entered on the register. All it says is, R enters a credit in the cash register for the amount of $1.
Right.
According to your entire argument, it has to say, buy one, get one free coupon, $1. All this cash register receipt said was credit, $1. Now, it's a single transaction, so you could go with that theory, okay, it's only one thing, so you know it would be. But this example 1 seems to go exactly to the contrary of the argument that the Commonwealth is making here.
I think the difference is the buy one, get one free coupon. I think that makes the difference
there.
there.
On the register.
Well,
That's the problem. What it says here, R enters a credit in the cash register for the amount of $1. It doesn't say that the receipt said $1, buy one, get one coupon. That's what your whole argument is. So I don't know. I just don't know how. I don't know how you can make the argument that you're making here when the published example in the regs doesn't require it to say buy one, get one coupon, $1.
I think I don't think the example's entirely clear, and I think it's buy one, get one free. It's clear there.
But that's the problem here. This says credit entered $1.
I understand that, and I don't want to put too much stock in a hypothetical written in 1994 when we have something that says scanned coupon. I think there's a little bit of an ambiguity in there, and I can't put too much stock into what.
But it's your reg.
Right.
It's your reg in your example.
And I'll just say, I think my answer is buy one, get one free is on there, and I think the Department of Revenue has been consistent in its interpretation of this regulation. So I just can't put too much stock into this one where it says buy one, get one free. I think that's clearer than we have here. I just wanted to address a couple other things based on some of the questions. I was saying before, the department cannot be present for every transaction, and we do rely on the buyers and sellers to get together to make sure that tax is not being overcharged. It's no different than filing your income taxes. There's a reliance on the taxpayer and the accountant to get together to make sure that things are correct. And that could have happened here. We had I think a savvy taxpayer who, instead of objecting at the point of sale, stayed silent and instead went to DOR, to the department, and asked for reconsideration of a prior letter ruling. So I don't think this is a case where the department is sort of facilitating fraud. We can't be present for all these transactions that occur within the Commonwealth, and we have to rely on buyers and sellers to get together. And in this case, the taxpayer was very knowledgeable about the law, and knowledge is power, and he could have corrected it then as opposed to now. I just maybe wanted to bring up one more point, Your Honor. I think to get back to just how the conclusion of the Commonwealth Court that every coupon was covered was erroneous. I know you've looked very carefully at the record. I would just ask you to go back and look at page 8 of the en banc opinion. You'll see that when they interpreted on-the-spot discounts, they interpreted on the spot to the exclusion to the rest of the regulation. There is no mention in there about how the item and coupon have to be described. And if there's an item and coupon that have to be described, it means there has to be an item purchased and a coupon presented that relates to the purchase. And again, scanned coup doesn't really cut it. We have to have objective documentation so that we can perform our enforcement function to ensure that proper tax is being assessed and collected. Unless there's any other questions, I think Your Honors understand my argument.
I have a question. What weight should be given to examples drafted by the department, put in their regulation for people to rely on?
I think it's a hypothetical, and obviously you have plenary authority. We're relying on you. I think this is also something else that the taxpayer brought up is about private letter rulings. They're not controlling. They're not dispositive. And Your Honors.
This isn't a private letter. This
Right.
is your published regulation. I mean, I don't mean to make too much of it.
I understand.
But I could understand someone trying desperately to comply with this and say, okay, all I have to show is there's a credit of $1.
I think we have to follow the plain text. And the plain text says separately stated and identified is one element, description is another element. Those can't be doing the same thing consistent with basic statutory interpretation or regulatory interpretation. If there's no other questions, we'd simply ask that your honors would reverse and deny the refund request here. Thank you, your honors.
Thank you. Could we hear from BJ's? We're really hoping you're going to make this nice and clear, because you're talking to a group of justices, some of whom really like to shop, and we'd like to understand this.
Well, good afternoon, Chief Justice Todd and other justices of the Supreme Court. My name is Jeff Daly. I represent BJ's. May it please the court, I'd first like to address Justice Doherty, a comment you made about BJ's. BJ's is a discount wholesaler, or a discount retailer. And what that means is their whole mission is to charge people less. So they want their customers to come in and spend less money. When they're charging and collecting sales tax, they're doing that on behalf of the Commonwealth. They don't keep that money. That money is then remitted to the Commonwealth. And so BJ's has absolutely no incentive to charge its customers more than it has to by statute and regulation. BJ's would love nothing more than the Commonwealth to allow it to charge its customers less sales tax. And so as BJ's enters into these transactions with its customers, it's doing so trying to faithfully apply the statute and regulations. Now, what we also have in play is we are talking about transactions that occurred 10 years ago. Technology's changed a lot in 10 years. So the point of sale systems that existed at BJ's at that point in time are what we're talking about. And that point in time, the point of sale systems referenced discounts, no matter what they were for, as scanned coup. That was the system limitations that BJ's point of sale system had in place. There was no requirement that they do anything else. Although there are audits by the Commonwealth every year to come in and make sure retailers are collecting and remitting sales tax the same way. There is also the Department of Revenue petition for refund process that does give taxpayers who feel that they've paid too much sales tax an opportunity to go directly to the person or the entity that now has the money, which is the Commonwealth, and get that back. And so I just wanted to address that up front. I'm not going to, I will answer questions if you would like me to on issues that he covered. But
you answered that perfectly, and I was somewhat in jest making reference to you, BJ. Here's the question or concern that I have. Since BJ's loves helping their customers, why not get a program in at your scanning booths, or put out coupons now that can specifically highlight so that the taxpayer can save pursuant to the statute or the code 33.2. Would it not be easy? I mean, if I could go into a restaurant and use my telephone to look at that little box and get a menu, which fascinates me, I'm sure you could put a coupon out that will pop up on my computer registration that says, buy one, get one, BOGO. All I got to get is a BOGO, or 6% off. I mean, that's an easy fix in today's technological.
Well, it may very well be, and I confess that may exist in BJ's today. I don't know. It's been a little bit since I've been at BJ's with a coupon, so I don't know if their systems do that or not. But your point's well taken, and I think BJ's is always evaluating its systems. It's a nationwide entity subject to 7,400 different taxing authorities, and so when it purchases a point of sale system and makes changes to that point of sale system, it's a pretty big endeavor. But your point is well taken. What I wanted to cover today, to the extent that your justices have questions, is how to evaluate the receipt. One of the things that the Commonwealth Court did in the majority opinion is they looked at it on a transaction basis instead of an item by item basis. And the proper way to evaluate how sales tax should be charged and collected is on an item by item basis, not on the transaction basis. And that's rooted in three things. It's rooted in the statute, it's rooted in the regulation, and it's rooted in the case law. So if you first look at 7202, 72 PA Statute 7202, it talks about sales tax being assessed upon, quote, each separate sale at retail, end quote. And so the question is, what does that mean? Well, the Pennsylvania Supreme Court previously held in Morris Half Laundromat that meant a sale of each separate item. And you look at not a transaction-wide basis, you look at each item. And the Commonwealth majority opinion here erred by not looking at each item, but by treating the entirety of the transaction as reflecting a single sale. And if you look at the regulation, that also is consistent with the idea that you look at it item by item. It requires that the items and discounts are separately stated and identified and separately described. The appellee does not cite any authority, any other authority, and really does seem to concede that Morris Half Hour applies here. What they do claim is, well, all that opinion means is you're looking at the receipt to see if the receipts separately list each item in coupon. But simply listing is not the standard, and I think this gets into a little bit about what Mr. Scarinci argued earlier, and I don't need to rehash that. I think justices get that quite well, and I'll leave that. But if you look at the majority opinion here, the background section on page 2, there's two concessions that I think are critical to this court as you're evaluating that opinion. They first say, for the two single item transactions we are talking about, quote, neither the item nor the nature of the discount was identified on the receipt in either instance. And so there, the majority seems to sweep away the identified portion of the regulation. And then with respect to the third transaction for 6 items, the court concedes, quote, once again, the receipt did not describe either the item or the coupons, end quote. So the court covers for these deficiencies in the receipts by saying that they don't matter because someone could discern from the information surrounding the transaction that all of the items were taxable and the discount applies. And then it shifts the burden in the way that Mr. Scarinci already addressed, saying that BJ's and the Commonwealth hadn't come forward with any situations that weren't covered by the regulation. If you look at the example 2 in the regulation 33.2, we already talked about the example of subsection 1. Example 2 I also think is instructive, although I agree with Justice Donahue that they're really not on all fours. And one of the things we don't have in example 1 is we don't actually have the cash register tape. We have the written description of the example, but we don't have the evidence that would have allowed us to evaluate even that example.
So it's a useless example. I mean, for purposes of this case.
I think in this case it's not on all fours.
Yeah, we're talking about what description is required.
That's right. And I think when you look at the second example as well, I think that's also instructive here, because in that example, you have a consumer who presented a manufacturer's coupon for a soft drink, but that's not described or identified on the register tape. So even though the store could have discerned that it related to the soda, they had the information. The cashier saw that it was a manufacturer's coupon for the soda. The regulation says that that does not reduce the purchase price because it's not described or identified on the register tape.
And that's true even though in this transaction, the coupon could only have applied to that soft drink because it was the only taxable item that was purchased.
Correct. And I think that's instructive to what we have here when you're talking about the single item transactions. There was a discount of the purchase price related to a scanned coupon, but what we don't know is what was that discount for. That evidence wasn't presented. And I'll note for the court that there was an opportunity to develop a record in front of the Commonwealth Court.
And how would you do that?
You could put in a declaration to your client. That's not been done here. There's no statement from Mr. Myers in the record, a declaration of any kind about.
What you're saying is the coupon would have had to, we'd have to be able to look at a receipt and tell what the coupon on a single item receipt was intended to be used for, rather than what it was actually used for. I mean, if it's one item, we know, for instance,
So-
on the tidy cat receipt, that it was used for the tidy cat. But what you're saying is that's really not enough because we should be looking at what it was intended to be used for, not what it was used for.
Well, what was
can see
the,
why
what was the
that's a little-
discount given for? Is the discount given because you purchased Tidy Cat or because you came in the store that day? That matters.
Could you help explain that a little bit further? I'm looking at section 33.2B2, which is the discounts section, which are excluded from taxable portion of purchase price. There's a list of discounts that are applicable to this situation, i.e. it'll reduce the amount of the purchase price. Would the coupon, would the receipt have to say manufacturer's coupon, this one's the easy one, manufacturer's coupon Coca-Cola. Okay, that's easy because you have a purchase of Coca-Cola and you have that's an easy one. But what if is being used is a volume discount? Does the register then have to say 50-cent volume discount? I mean, is that what the idea is here?
Yeah.
To establish that the coupon, the discount that is being taken is a discount that is cognizable under this section of the regulation.
Yes.
So it'd have to say employee discount.
It would have to say enough to describe it to fall within this regulation to exempt it from there. So,
Regardless of the fact that it's obvious what it was used for. Regardless of the actual fact.
so the intent, I think, of the regulation was for the Commonwealth when it was coming in and doing its audits and evaluating whether tax was properly collected, if it could evaluate that at that point in time. And so it would be looking at the cash register receipts. And so there is a tendency when we're talking about this to start looking at it from the perspective of the cashier and the customer at that moment in time and what the cashier could have discerned. And you might imagine all of us having shopped, different cashiers doing different things at different points in time, and that's not what was intended. This was trying to create some uniformity, and really, when the Commonwealth comes in and does its audits of BJ's and other retailers, are they collecting sales tax appropriately here? And the evidence that they looked at to determine that is how are the items and the discounts described on the receipts?
Well, how would you distinguish pursuant to 33.2B2 the difference between a wholesaler or trade discount as well as a store manufacturer coupon, being that it's BJ's, which is a store as well as a wholesale?
You're right.
If I'm following your argument, we need to distinguish. So BJ's is a wholesaler, but they're also a store. So how do I distinguish between the little book you get in BJ's that you could go through and pick out your discounts?
Well, for BJ's, there may be no distinction, frankly. There may be coupons that they offer that are both wholesaler coupons and store coupons, because they're both. So I don't know as though it would have to fall into one bucket or another because of the nature of BJ's being different than some other stores.
So let's go back to the Tidy Cat or the One Cat, which was the single purchase.
Right.
The argument is that they should be disqualified because there's no identification. Well, the identification is either, my argument, it's a wholesale, retail, or a discount, or it's the store discount. Either way, it's a discount from BJ's for that one item. How is that taxable, not excludable?
Why? I'm not following why you're saying it must become from BJ's. We don't know. All it says is scanned coupon. We don't know if that was something from Tidy Cats, from something from BJ's, something from some credit card company that had a relationship with BJ's, or we don't know the nature of who issued the coupon, what it related to. It just says scanned coup. That's all we know about that.
Okay, Counsel, and maybe this is just a technological matter though, but in that example that you were just giving, you don't know whether it was a purchase of Tidy Cats and a coupon was used that only applied to Tide products.
Could very well have been that the coupon was applied incorrectly.
And I suppose nowadays the register wouldn't accept it if you didn't have that product as something that was purchased. But that sort of indicates part of what the problem is. You just don't know.
We don't know. There
what-
could have been,
what
could have
the
been
nature
coupon.
of the coupon.
Yes, it could have been error, yes.
But no store does that. They reject them if they're expired.
Now,
Yeah, I think sitting here in 2022, they think that's probably correct.
but that's today's technology.
But
Yes, that
you
would preclude
raised an interesting question. Are you saying that wholesalers like BJ's or the others don't accept, or they do accept coupons that you may get in the Inquirer or the Post-Gazette? My understanding was the exclusive coupons were for their own.
So they offer many different types of discounts when you walk into BJ's. As a member, you get discounts just like off the top.
You can't go in unless you're a member.
That's correct. So you get a discount that way. But my understanding is, and this is not part of the record, just based on my understanding of working with them, that you can use many different types of discounts. There's not limited to discounts or coupons that you get in the store. I'm sure there are limitations on it. I don't know if you pull something out of the Inquirer, if you could just take a generic Coca-Cola coupon and use it at a BJ's. They would probably have to have some type of relationship with Coca-Cola with respect to that promotion, which they do all the time. That's often how these things are issued, promotions that they enter into with the various suppliers, the Coca-Cola or any other product.
Thanks.
Thank you.
I have nothing further. No, I have nothing further. I think Justice understands. Thank you.
Good idea.
May it please the court, Chief Justice Todd and other justices of the court, my name is John O'Connell and I represent John Myers in this case. I would just like to start by saying that I am here to argue only for the accurate collection and assessment of sales and use tax in the Commonwealth. There is no argument here or no disagreement between the parties that sales and use tax in excess of the real purchase price of the products was collected. What my opponents would argue is that it is a permissible overcollection. Overcollection occurred in this case no matter what. The three receipts before you today, two of them are single item, single coupon receipts. My client bought those items and obtained those receipts from BJ's after receiving a letter ruling from the Department of Revenue in which the Department of Revenue opined on August 13th, 2014, that a single item, single coupon receipt would establish a new purchase price and sales tax would only be owed on the new lower sales price. My client went and obtained the August 22nd and August 25th receipts by buying kitty litter and cat food, and then the Department of Revenue, when confronted with those, reversed course. So not even the Department of Revenue in this case can completely comprehend and understand its own regulation and uniformly apply it. I would like to posit that what we have here is a regulation that requires that things be separately stated and identified in one section, in 33.2b itself. And then if you drop down to 2, that is where the described word appears. So the receipts here, as reproduced in full in the Commonwealth Court panel's opinion, they clearly satisfy the regulation. We have an item. Then we have an indication of a discount. That is satisfying the separately stated and identified portions. And then the discount is described. It is listed as a scanned coup, obviously a coupon. There is no issue that there's some kind of percentage discount on goods purchased on those days. I've set forth the calculations in our brief that could not possibly apply. You know, no one is saying that there are 8.7% discount coupons commonly found in newspapers.
Well, let me understand your argument on this. So how can I tell, based upon those cash register receipts, that the coupon that your client used was for Tidy Cat as opposed to a coupon that was for Coca-Cola that was just entered by the cashier, or it was a coupon that was handed to him going in the door of BJ's that said, it's Happy Thursday, $1 off your purchase? So how can I discern that so I know that the regulation applies?
Justice Mundy, this is a fox guarding the henhouse problem. BJ's collects all the information at every stage of the process.
Tell me how I can, by looking at the receipt that's in the record, how can I tell whether the coupon that was scanned is A, B, or C, as I just gave you some choices?
So my client has verified the submissions to the Department of Revenue, to the Board of Revenue. The affirmations made in all those appeals are true to the best of his knowledge. He went in, he made those purchases. He provided a manufacturer's coupon for Tidy Cat. That is what is in his appeals. That is what he has verified. He asked for he submitted a $3 coupon. The coupon was accepted. He purchased the items. He went home with the receipt.
So through that answer, are you then conceding to me, by looking at the register receipt in isolation in my trial notebook here, there's no way to tell what the scanned coupon was for that was used for the Tidy Cat purchase?
Your Honor, I think the inference that can be made from the receipt is in favor of my client. It is a round number coupon on a single item purchase. The coupon is for $3, which is a large amount. BJ's no doubt sells many items in its store which are less than $3. So that if my client bought a candy bar and submitted a $3 coupon because he happened to shop at BJ's at that day, that would be something BJ's would never offer, because it would require a refund to my client of $1.75.
And whose responsibility is it to correct the receipt? BJ's or the Department of Revenue, since it's their statute or their regulation?
It's BJ's, Your Honor, that is fully responsible for the receipt. BJ should, of course, not be permitted to operate in this kind of gray area. And you'll note in the record at every stage of these appeals, we submitted an entire purchase history in which BJ's actually identifies the type of discount offered, and then in a summary of that purchase history lists coupons listed on every day. For example, if the reproduced record was before you on page 67A, you would note that my clients purchased an $8.99 Lance cookie assortment or cracker assortment and got an instant discount. It's listed here as a rebate of $1.50. So it's listed, they can maintain it in their system.
They got cookies and $1.50.
So the one thing that this case proves is that my clients like snack food, and I admit this. But they, BJ's collects this information, and this is 2012. This is from before the time of all these receipts. Now it's the intervener's own document. They produced it. They provide it to my client to show the amount of discounts and benefits he receives from this membership. But the receipt they print out at the point of sale is designed not to display all this information. And that is it is a clear attempt to overcollect. And what we have here is a rational...
Wait.
Why would they do that?
On what basis are you saying that? Why do they want to collect more tax that goes to the Commonwealth?
So the BJ's motivations are entirely opaque to me. We have only, we're here on a stole-off appeal. So the original case down in Philadelphia has been stayed during this entire process.
Single-handedly trying to protect the public fisc.
And I am here to protect the taxpayer, Your Honor.
At 3 cents a pop.
Little by little.
At 3 cents a pop. There.
Yeah, I mean, your comment seems, counsel, to be indicative of some kind of an allegation of fraudulent conduct on the part of BJ's, and that's just not in this record.
I'm not making I'm making an allegation of overcollection. My clients deserve to pay the correct amount of tax on these products. The Commonwealth Court rightly looked at these receipts, at these transactions. You can see the T or the N marked on the receipts where something is taxable and non-taxable. Commonwealth admitted that in its briefs below. Commonwealth Court found that they had admitted that. And that is the key to allowing the reduced purchase price on the multiple item receipt. All of those items are taxable. Each coupon is listed next to each item. Scan coop, scan coop, scan coop. You can tell what it applies to. There's, well, they're in seriatim. Like if you look at the Commonwealth, if you look at the Commonwealth Court's opinion, the panel's opinion, it sets out the receipt. And
Is that page 17?
that sounds right, Your Honor.
Yeah. 19's a multitude of several purchases. The other 17 was the one that we were speaking of, the cat litter.
Yes, Your Honor. 19 is the page I was thinking of. So what you have are coupons being applied to taxable items. There's no reason, and they're round numbered coupons. These are not like you get 10%.
Goes with the second item on the list.
Well,
It was sold for $13.29.
Your Honor, this coupon does not contain that information, but BJ's maintains it in their own system. So there's no reason why it can't be printed there. There's no reason to engage in overcollection.
Following your theory, if they maintain it and they're audited by the state, then it's incumbent upon the state to seek that out. It's not a BJ burden for utilizing a mechanism at the machine that it currently has, correct?
Your Honor, as far as I understand it, the state has not complained about BJ's practices with respect to these receipts. I don't know their internal audit process.
All right.
Got it.
Do you have anything more you'd like to say in conclusion? I'd like to say I think we've got this, but
I will simply say that I'd like the court to affirm the en banc opinion of the Commonwealth Court.
All right. Thank you very much. Mr. Minner?
Argument is adjourned.
Job well done.